Right. Are we all ready to go?
Yes, my lord.
Very good. Dr. Jamar, you're still under oath, you understand?
Yes, indeed.
Thank you very much.
Dr. Adele, we were talking yesterday about the difference between BUA and GFA. I was going to move on now and just discuss with you another issue, which is the affection plan that you talk about in your witness statement. Do you remember that? And the complaint there relates to a plan which was required to be produced once the road had been settled across the northern border of the plot. Yes?
Yeah, the affectionate plan for any development is needed basically to get the NOCs and to get the designers to do their work based on the affectionate plan.
Yes. So, but the affection plan was going to show where this new road was going to go on the northeast side of the plot. Yes.
Yes, that's part of it. But the other thing is the other borders. All of that affectionate plan, and called in Saudi the Cooke, basically shows you all the borders of the site. So it's not only the road, it shows everything. That's why you cannot do anything without having the affectionate plan to put your building, okay, according to the affectionate plan you have. You have setbacks from, for instance, on the roads, you have setbacks and easements on the pedestrians, all of these kind of things you need because of, you cannot do anything without it, basically.
But the only part of the plot that it was looking like was needed to be changed was the northern border, the northeastern border, where there was a new road that was being introduced. Yes.
No, it's not only that. As I mentioned, that will show one side. What about the other three sides?
Yes, but everybody knew by the time you got involved in this project, everybody knew where the other sides of the plot existed. They were, for example, on the master plan, weren't they? The only thing that was going to change was the northeast border, depending on where the road was going to go. Yes.
That is in a way, correct. But in addition, remember the building was designed for a different plot. Now you want to move this building and put it on a different affection plan, different plot plan, site plan. Okay, so that is the most essential thing that you need before you even start doing anything with the design. Before doing the concept, because you need that to see where your building will be sitting.
All right, well, I'll come on to that in a moment, but it's right, isn't it, that before you could get the affection plan settled, they needed to know where this road was going to go?
Yeah, I mean, partly you need to know, obviously, where the width of the road, because at the beginning they said 18.5, then they said 14, then 12, then 10. So you need to know the width of that road. But you cannot do anything with any plot. You cannot scratch the ground without having an affection plan, okay, when you approach the authorities.
I'm getting an intervention from the stenographer. She's concerned that you're too far away from the microphone and therefore she cannot hear you very well. Is it possible for you to position yourself closer to a microphone? Please don't is there somebody who can help? Could you sit down, please, Dr. Adele? Don't wander off. Is there somebody with a?
I have with me Osama assisting me, so is that?
Let's rely on him, perhaps, rather than wandering around.
Okay. Is this better? Is it better now?
It's better from my end. Let's see how we go. Thank you very much. Right.
There's another problem. I can't actually see anybody at the moment. All I can see is the discs with people's initials, and so that's not helping. I've got somebody from my technical support trying to work on that in the background so we can carry on, but I really am struggling to hear the witness much more than I was yesterday.
My lord, I think we're in your hands as to whether you think we should struggle on or give the stenographer a few minutes to try to resolve the problem. It may simply be a matter
it needs to be sorted out fairly quickly.
Yes.
I think we need to get it sorted out because the transcriber can't operate effectively.
I'm going to try and leave the call and come back and see if that helps.
That sounds
Yes, I
sensible.
think that's what people tried yesterday with that often the way. But Dr. Adele, it seemed to me that if your assistant could move the microphone closer to you, we were getting a bit of an echo. If that's not going to be impossible because of the papers.
Now, the good thing is I can now see everybody.
Is this better now?
No, that's worse. Slightly fainter.
Well, move it maybe.
Perhaps transcriber tell us when she is happiest, so to speak, with the result.
Better now or worse, so that we know that bring it forward or backward or what? Is it better now?
What do you think, transcriber?
It's slightly better. It does help me that I can now see the witness. So let's give this a go. Thank you for your patience.
We'll try this. Thank you very much, Dr. Adele.
Okay.
Yes, thank you, Doctor. And if you could please just remember, let's try to speak a little bit slowly, to help the stenographer as well. That might improve things too. All right. I think that where we'd got to was you were agreeing with me, I think, that in order to settle the affection plan, one of the things, there may be others, but one of the things that needed to be resolved was the placement and size of this new road.
Yes, that's you need that, but you need basically the coordinates of the site. And do you have straight lines between the corners? Do you have a curved line? So you need exactly the borders of the site. That is what meant by affection plan. Now,
yes, Dr. Adele, sorry. Again, we just need to listen to the single short question that I'm asking. And if I can just ask you to focus on answering that question, rather than going back over anything that's been said before or dealing with other issues, then we'll move through this quite quickly, I think. Thank you. All right, now you are aware that settling the placement and size of the road was the responsibility of the Road Traffic Authority, weren't you?
RTA.
Yes.
Yes.
Yes. So it's
RTA rule. It was RTA which introduced this road.
Yes.
Basically. But did not know about it until the meeting I had on 13th of July with Turner.
Yes.
We weren't aware about it before.
Yes. Right. So the Road Traffic Authority has to decide where this road is going to go. Yes.
Yes.
And so it's not up to the defendants to simply make that decision by themselves, is it?
For the road, no. But the argument we're putting is that RTA, the IFC, TCOM, all of these are authorities, and they could expedite the approval, of the road. It should not have taken that long, nearly a year, to determine the width of the road and where it's going to go.
So you describe your complaint about this as the argument that you are putting. So in effect, you are making, are you, an argument that the defendants ought to be responsible for any delays caused by the RTA?
What I'm saying is that they could have expedited this matter. They could have approached the authority, RTA, and resolve this matter quicker with them in order to release their facility.
Now, you were not involved in the discussions between the DIFC and the RTA, were you?
Of course not.
No. So you have no idea what passed between the DIFC and the RTA, do you?
No.
So you are not in a position to say whether or not the delays in those discussions were the responsibility of the RTA or the responsibility of the DIFC, are you?
No, I'm not presented with any evidence, okay, that they approached the RTA 100 times, but the RTA are not responding, or I don't have all of this evidence. So, I mean, it goes without saying that, no, I'm not aware.
And then once the road is settled, it's then for TCOM to produce the affection plan, isn't it?
Yes, which is another authority.
And it's not the responsibility of the defendants themselves to produce the affection plan, is it?
No.
So you can't, well, all right, I'll leave it there. The defendants actually negotiated with the RTA about the size of the road, didn't they?
This is what we have been told, yes.
Yes. What, you doubt that? You don't believe them?
Of course, why should I doubt it? I believe it.
All right. And they sought to reduce the size of the roads, didn't they?
This is what they say, yes, and I tend to believe this. Obviously,
Yes.
It's in their interest that they reduce the size of the road as well. This is their plot at the end of the day.
It's in everyone's interests, isn't it? It's in the interests of the project,
Mutual interest.
the road, yes? Sorry, again, rather than nodding, I'm going to have to ask you to give a verbal response. I do apologize. It's for the transcriber. So they were trying to reduce the size of the plot, indeed from 18 meters, sorry, the road from 18 meters in width down to about 12 meters in width, yes?
Yes. And that is in both interests of the IFC and the developer, CHF.
So far as you were aware, in doing that, they were doing their best to push the project forward and improve the prospects that it was going to be a success.
I can't confirm that they were doing their best because of, as I said, the lack of responsiveness from the DIFC. When I communicate with them and when they give us, I mean, if you look at their representative, Turner, okay, who on 13th of July said that he was going to give us the affection plan along with the road on the day, and you know, when was that actually given to us? That is a very, very long time, despite almost daily follow-up from our side.
Yes. But again, you can't say whether that delay was caused by the RTA, whether it was caused by TCOM, or whether it's caused by the DIFC.
I have no evidence to confirm who was actually responsible for the major delay. All I'm saying is that, in my opinion, because of the lack of responsiveness from the DIFC when we communicate with them, they could have expedited this matter. This is what we're saying.
Well, that's your impression, but you don't actually have any direct contact with the RTA or any direct information about the discussions with the RTA on which to base that conclusion, do you?
No, that's my conclusion based, as I said, on my experience with the IFC, and I think if you look at the email I sent to Ziad Al Ghaffar, I didn't know when I sent that email that I will be sitting here, okay, to be cross-examined. Okay, when I said to him that the DIFC guys don't seem to be bothered with time, and for us, every day that passes without progress is too long a delay. So this is, as I said, based on my experience with the DIFC, dealing with Mr. Najjar, we're dealing with the Turner, Mr. Firas Hamouda, and I dealt very little with Mr. Bishr al-Barazi and the other, other people. But these are my main contacts: Turner, as I said, and Mr. Najjar. And there was obvious lack of communication between internally. When we asked Mr. Najjar, he tells us, well, I haven't seen yet Mr. Bishr al-Barazi, and they are in the same building, but nobody sees one another or talks to one another about these very, very extremely important, issues.
All right, and then on the 25th of February 2009, you attended a meeting with the DIFC. Do you remember anything about that meeting?
I think there is, minutes, if I remember correctly, about the meeting.
Yeah, so you know which meeting I'm talking about. Do you remember anything about it sitting here today?
I read the minutes, I don't
yes,
know
but
how long ago.
Sorry.
Do I remember anything about it?
I have the same problem again from yesterday, Dr. Adel. I keep thinking that you've finished your answer, and then I keep talking over you. I'm going to try to stop, but do be aware that if you have long pauses, I will probably assume that you've come to an end. So do please try again. The question was, thinking back to that meeting, do you have a recollection, a clear recollection in your head of what took place in that meeting, or are you really relying on the minutes?
I'm actually relying on the minutes, to be honest with you. I mean, 13 years back is a long, long time. I
see. All right. Can I ask you to look very briefly at these minutes then? It's Bundle F, Volume 3, please. And it's page 1435 is the start of it.
Can we have the tab number as well, Mr. Montague-Smith, if you're able?
I'll try and give the tab numbers, and I'm sure he can find it there.
79.
Thank you. I'm sorry, I'm working from a digital bundle, my lord, which it's not very easy to see where the tabs fall in the digital bundle, so I apologise for that. I'm sure someone will start shouting tab numbers at me now. So if you've got that, you see the meeting minutes there. That's the 25th of February 2009, and we can see that you were present. You're listed as number 9 on that. And then if you can go over the page, please, to page 1436. Do you have that?
I do have that, yes.
Under the section 3, the affection plan, it says 3.1.1. DIFC stated that the affection plan is ready, except that DIFC would like to ensure that CHL is aware of the 12-metre wide road on the northeast side of the plot, and that they have no objection for that part of their plot to be used by RTA. The implication for having this road would be losing at least 12 metres from PA01 plot from the road level and above, with the possibility of losing part of the car parking spaces in the basement immediately below. And then 30102, the DIFC added that they haven't yet given RTA the consent to build the said road, pending CHL approval. So at that meeting, the DIFC is telling you that we've got finally an agreement from them to reduce the size of the road to 12 metres. Can you please sign off on this from the CHL side? Yes?
Yes.
And CHL, you don't say at that meeting, yes, we consent. You go away and think about it, don't you?
I seem to remember that I've written we can accommodate this road subject to compensation. I can't put my hands on that.
I see. But that came later. That did not come at the meeting, did it?
Yeah, by the way, we did not object to the road from day one. When we were told on 13th of July, 2008, we said
No, Dr. Adel, you've got to listen to the question and answer the question. So by the way is not going to be an appropriate answer. We really need you to listen to the question and answer that one. Some of these questions are pretty innocuous, and they're just to help us move through and understand what's happening next. So can I ask you one more time, please, just to do it that way? So at the meeting, you did not say, on behalf of CHL, yes, we agree to this.
If it is not minuted, it could have been said, but not minuted, or we did not say yes.
So you're speculating that it might have been said?
Might have been said, but not minuted, and it might not be said. That's the two possibilities.
But you've got no reason to think it was said at the meeting?
And I have no reason to think it wasn't, because it's not minuted. Because the minutes are not verbatim of everything is said during the meeting.
What is also not in the minutes is any suggestion at this stage that telling the DIFC that this is all terribly urgent because you need it in order to get going on the design. So is it right that you didn't say that at the meeting either?
Can I repeat the question, please?
The meetings don't contain any reference to you telling the DIFC that this is all terribly urgent because you need the affection plan to get going on the design. So is it right that you didn't say that at the meeting?
We did not say this. We've written so many times. So what do you mean we did not say this? I'm sure we said, and they are aware of it. This goes without saying that we've been asking for the affection plan for a very long time. Whether it was said in the meeting or not, it is a fact known to the IFC at that time.
All right. Ultimately, it looks like you agree, if we go forward in the same bundle.
Well, before we go there, Mr. Montague-Smith, I think you should look at the second item, 030102 on page 1436 and 1437, which talks about the DIFC not giving consent until they have CHL's approval.
Yes.
So what does that tell you, Dr. Adel, about whether or not you gave approval at that meeting?
I actually would be very, very, very surprised. We have not said, yes, go ahead, we have no issue. But as I said, I think I'm not there to waive the client's rights. No. So, maybe the client was asking for compensation in return. So they did not say it. Or we said, go ahead, we'll discuss the compensation at a later stage. I can't recall, remember everything, what was said exactly in that meeting. And if I tell you that, yes, I can recall this, what happened during that meeting. I mean, would you believe me after all this length of time?
All right, thank you. If actually this might help if we go forward to page 1447. 182, tab 182, I'm told.
Yes.
Yes, so do you see there on page 1447, that's a letter from you to the DIFC. Do you see that? And it says you refer to a meeting that had taken place on the 9th of March. So it sounds like there was another meeting prior to this. And then do you see in the second paragraph, as a response to your request during the meeting, we hereby confirm that we have no technical issue should RTA decide to construct the said road with a width of 11.5 meters. And then you say TPM will leave the discussion about the commercial compensation for losing a huge area above and immediately below the road level to DIFC and Concept Holdings higher management. And then you ask for the affection plan in short order. So it looks like actually you didn't give the consent at the meeting. In fact, you gave the consent a couple of weeks later, didn't you? On the 11th of March in this letter.
You know, this is your conclusion. I don't know what happened, but at least this is a confirmation that we have given the consent in this letter. Now, technically, we have no issue. We will have to live with the whatever RTA decide, whether it's 11 and a half, 12, 14, 18. It just we needed to know the confirmation. That's all.
Yes, and then after you give that confirmation, TCOM released the affection plan to you in April. Yes.
Yes. By the way, it's not the final. I believe in April it was it did not contain all the information required for an affection plan from memory. I think it lacked, for instance, the height, the mixed use. So I don't have the affection plan in front of me, but I'm sure we've written that it lacked some information or details inside the affection plan. So to be there.
I think in your statement, if you got your statement in front of you.
Yeah.
If you turn to page 124 of the bundle, paragraph 74. Do you see you say, if you've got that, I followed up with Mr. Mushwar.
Yeah.
Just hold on 1 second, please. I followed up with Mr. Mushwar on the 14th of May, 2009. I informed him that we finally received the draft affection plan from TCOM on the 30th of April, 2009, 10 months after we first requested it. And then you say, however, the affection plan did not show the agreed mixed-use percentages, and then you follow up on that. So at this point, though, you've got the plot parameters. It's just what's left over then is an agreement of the mixed use. Yes?
Yes.
So all issues in relation to the road are finalised when you receive this document in April 2009, yes?
Yeah, but the word received draft affection plan.
Yes.
It's not a final. You know, it could change when you say, you know, the word draft.
I see. So you're complaining now, are you, that you didn't have what you needed even in April 2009 in relation to the road?
In relation to the road, maybe we have, you know, but this is not enough. We need other things for the consultants to complete their design and start asking for NOCs and permits from the authorities.
Yes, and what you needed was the mix use, the mix of use for the property.
Yeah, that was one of the things we needed, and the building height.
Right. Now, in relation to the mix of use, you have seen, haven't you, the 2008 shareholders agreement that was entered into between Concept Holdings and the DIFC, yes?
It's the one you showed me yesterday, yeah?
Yes. You've seen it, yes?
Yes.
And are you aware that that does not have anything in it about what the mix of use for the land was to be?
Yes.
So there was nothing in so there was nothing in that contract determining the mixed use, and therefore Concept and the DIFC had to agree something on the mix of use, yes?
Yes. But if you look at the consultants' proposal, 1st of June, I believe, or 3rd of June, 2008, and then the one where we signed the LOI based on it, both of them give a mixed use of 8875. So where did this information come from? How come the client, this is before me joining, by the way, PBA, how come the client gave these without, based on what? There must have been some kind of agreement. You know, the logic says between Concept Holding and DIFC.
Oh, I see. So you assume that there must have been an agreement between the two parties because Perkins and Will were preparing a design on the basis of a particular mixed use.
Yeah, the designers were.
In fact, sorry, did you have something else you wanted to add?
Okay.
Thank you. All right. Paragraph 20 of your witness statement. Can I just ask you to look at that briefly, please? Do you say, once you get it?
Yes.
You see there, you say, I also told Mr. Suleiman Al-Majid that I instructed P&W to proceed with the design based on the information provided and the DIFC master guidelines. So from that, it looks like you are telling Perkins and Will to follow the DIFC master plan.
Not only master plan, the guidelines. When you design, okay, for such big development like the IFC, like the Abdullah Financial District, you have to have a design or master plan guidelines. So each designer for each plot will have to comply with.
All right. So, all right. So are you saying there then that you were or were not telling Perkins and Will to comply with the DIFC master plan insofar as the DIFC master plan set a mixed use?
Perkins and Will were provided with a mixed use, and they were told to follow this mixed use.
Yes.
Okay, so I cannot see that I'm now telling them no, use a different mixed use. If they in the guidelines. So
maybe I'd misread that part of your witness statement as saying something different to what you meant. But when you're talking about the master guidelines, then you are not talking about the mixed use in the master plan.
Talking about everything in the master plan guidelines, and they are aware of it because they did before that the building by the man, and I was a project director at that time. Perkins and Will themselves, so they are aware of this, but they need to be reminded to use the guidelines.
Yes, but there's a mixed use in the master plan, isn't there?
There is a mixed use, but in this case, they knew from day one they were going to use a different mixed use, and they submitted their proposal based on that mixed use, and they started their design and their concept based on that use.
I see. And they started their design and their concept when?
Although I was told by Mr. Hussein Chokami, that they started even before signing the LOI, but 7 days from the LOI, they should have started the concept design.
Yes, but this mixed use that they had adopted of 80% offices, I believe, that is something that had already been set before you came into the project. Is that what you're saying?
Yes. Yes. Because as I said, the proposal submitted early June before I joined was based on this mixed use.
Yes, and indeed, from the documents that you have seen, therefore that mixed use had been adopted earlier than your joining the project by a few months. So it must have gone back in 2008, sometime very early in 2008, that there was, you assume, this agreement as to the mixed use.
I cannot confirm a particular date. All I'm saying is that the mixed use that Perkins and Will and D1 submitted before I joined, okay, was 8875. That was the mixed use. So they must have taken this from obviously the client.
All right. If I can ask you to look at your witness statement at page D112, please.
Yes.
Do you see there what you say is that crucially I recall that in the summer of 2008, Mrs. Suleiman Al-Majid and Mr. Barazi separately agreed the above departure from the DIFC master plan mixed use of 52% residential, 34% offices, 7% hotel, and 7% retail. You've told us now that actually you do not have any particular recollection of that agreement. It's an assumption that you have made, yes?
What I'm saying now, I'm referring to the designers, the mixed use used by the designers before I joined. Okay. Then obviously, as I said, we go through a lot of discussions separately with Mr. Sulaiman Al-Majid, and this is what I've been wondering. Where did you get this pictures from? It's because this was agreed at some stage between CHL and DIFC or DIFC rep. I think in this particular it was Mr. Bishop.
Right, but you have said in this witness statement that you recall that there was this agreement. Do you not think that that sort of language is a bit of a misleading way to express yourself in circumstances where you now tell us you do not have any personal recollection of an agreement?
No, I think the wording maybe should have been that I recall in the summer of 2008, I've been told by Mr. Sulaiman Majid that they've agreed this mix.
And you say
when I came in this summer, then obviously that was the mix that we were given, and the consultants were working. So I recall at the moment, maybe that I was told by Sheikh Sulaiman that this was the mix agreed with DIFC.
All right. Let's just focus in on this for a second. So earlier, I think you told us that the reason why you thought there was an agreement was because it was recorded in the documentation. You are now telling me, are you, that Mr. Sulaiman Al-Majid told you that there was an agreement?
I cannot recall, obviously I cannot remember, but I'm on daily discussion with Mr. Sulaiman Al-Majid. So I know that there was an agreement between Mr. Sulaiman Al-Majid, and he said, this was agreed with Bashir that this will be the mix. Okay, we don't want the hotel. So the hotel is out of the equation, and we have 88% offices, 7 residential and 5 retail.
Right. I'm just trying to get the source of your information. So you don't recall having a conversation with Mr. Sulaiman Al-Majid in which he tells you this, I agreed with so-and-so on this date that the mixed use would be X?
I think I must have obtained this information from Sulaiman Al-Majid and nobody else, because he was the person I was liaising with all the time. So he must have given me this information that that the mix is 88-75 was agreed. Okay, and that's why we are moving forward.
Yeah. So when you say you must have got the information from that, what you're telling us is that you don't actually have a specific recollection of it in your mind as you sit here today.
To be honest with you, I cannot recall exactly the day and the time and when Sheikh Sulaiman told me this, but I'm sure he must have told me this.
Yes, I think I'm not criticizing you for being unable to remember something that happened 15 years ago. So don't misunderstand my questions. What I'm trying to get to is the source of these assertions that you're making, and trying to identify whether they're derived from documents, whether they're derived from actual recollections you have as you sit here today, or whether they come from something else. That's all. Now, you do not recall then, presumably, any discussion, for example, to the effect. I'll move on. Now, you understand, don't you, the purpose of having a mixed use determined in the master plan? Yes?
Yeah, of course.
And you accept that the DIFC couldn't just let developers build whatever they want to build on each particular plot, yes?
Yes, but there is a flexibility.
It's flexible, of course, but there has to be an overarching policy, doesn't there, about how much of each different type of unit gets built in the DIFC.
Yeah, that's right. I mean, many of the plots, obviously, the DIFC were not a partner, and maybe they were very strict in complying with the master plan. But in this case, they are a partner. So, you know, I'm sure they will have some flexibility, you know, because at the end of the day, it's in their interest.
Yes, but if different uses have different values, then if they give you more, then they have to give someone else less, don't they? So there's a cost to the DIFC in allowing an amendment to the master plan, isn't there?
There is more demand for the power and other utilities when you have offices, obviously. But I think when you have big developments, you always allow for some flexibility. So, I've been involved in big developments, and I know that you always allow a certain mix. And you know, I'm sure they've done that not only for this plot, maybe for other plots.
Right, and what you were asking for, what you wanted to build on this plot, was a very significant deviation from the mixed use identified in the master plan, wasn't it?
Yes.
Yes. So to give the headlines, for example, the master plan provided for 34% offices, whereas your plan provided for 88% offices, yes?
Correct.
And the result of that is that the development that you were proposing would have had a significantly greater load on the infrastructure, chilling, water, power, parking, than if the project had been consistent with the master plan, yes?
Yes.
And so once you'd got past the proposition that there might have been some prior agreement, you got into a discussion with the DIFC about what the mixed use was going to be for the project, yes?
Yes.
And you wanted 88% offices, and then the discussions progress. And do you remember this? But in May of the same year, the DIFC offered you something less. We can have a look at it, can't we? It's page 918, which is in volume 2, F2, sorry, F volume 2, 918. Tab 119.
You can display it, or you want me to look at it here?
Yes, let's have a look at it, please. So you've got volume 2, bundle F, and it's tab 119, I believe. If we go to page 918, please.
Okay.
You request 88% offices, and on the 13th of May 2008, they come back to you. Now, is this prior to your involvement in the project?
Yeah, I'm not involved here. As I said, I think from very late June 2000.
Late June, I see. All right, but you presumably became aware of this history when you became involved in the project and were dealing with the questions of mixed use.
Yes.
Did you? So did you look at these documents at the time?
From the time I came, as I said, you know, I've looked at not all the documents, but at least some documents, some emails at that time. I can't recall which one I looked at, which one I didn't.
Yes, all right. But are you aware of this particular offer that they made to Tamniat, to Concept? You see, it says, "Dear Mr. Suleiman, hope this finds you well." Do you see that over the page?
Yeah.
As per our DIFC master plan, here's the breakdown. And then underneath that, underneath the GFA of the project, he says, "We are therefore allowing Tanmiat a special case of a 10% change of mixed use from that noted above. However, the mixed use you have requested extends beyond the 10% change," and then explains the importance of the DIFC master plan. So in terms of flexibility, they were offering you flexibility. They were offering concept flexibility, weren't they, from the master plan?
Yeah, when you mean offering CHL
Yes.
flexibility. Okay. Yes, they are offering 10% flexibility.
So the position that they were taking was perfectly reasonable, wasn't it?
The DIFC?
Yes.
Yeah, by offering flexibility, that is reasonable, but whether I'm not aware of what happened between, you know, the chairman of CHL and the DIFC. Okay, because if you look at all the DIFC, there are many people writing. You know, this is Shahab and Musa Doni. I met, if I remember correctly, few Adil Abdullah, Najjar, Bishir, and Mr. Mishahur maybe, and I'm not sure if I met this guy. So each one of them is you know, starting something different. For instance, if you look at Adil Abdullah, he approved the GFA in 2007. We talked about yesterday. So
yes, but I'm asking you about discussions about the mixed use. So should we try and focus in on the mixed use and not talk about the other issues for now, because otherwise we'll just have a long discussion. What I'm suggesting is that at this stage, unless there was some clear agreement, and we'll leave that to one side for the moment, this is a perfectly reasonable position for the DIFC to adopt, yes?
yeah, but if you look at obviously CHL were very unhappy with this response of Mr. Shahab. And that is obvious from Mr. Sulaiman writing to Mr. Abdullah, telling him, you know, well, check this and call me immediately.
Yes.
So this has upset obviously CHL, and
yes,
you know, they would not have been upset had there not been a previous agreement with somebody within the IFC for a different mix than the one in the master plan.
We'll hear from Mr. Bishop-Arazi, and we've talked about whether there was an agreement, but let's put that to one side for the moment. The position that they are taking is a reasonable commercial negotiation given the backdrop of the master plan.
I wouldn't say no, but as I said, I don't know. I'm not aware of the agreement between the two parties.
All right. Now, after this, happens in May, we go forward then to August, and if you can go forward to page 1016, please.
1016?
1016, please.
Tab 136.
Tab 136, thank you.
Okay.
And then you'll see there is a letter. It looks like it's a letter from TPM. It's dated 11th of August 2008. Now, you were on board with the project at this time, yes?
Yeah, yes. I'm
So were you involved in this letter? Do you remember this letter? at the time.
Yes. In fact, I must have drafted this letter to Mr. Ziad as well.
So it's signed off by somebody else, but you think you've drafted it, and you say we'd like to bring your attention that the revised mix was agreed, and then so you're asking again for the mix to be agreed. So the same mix. You're asking again for the same mix, 88% offices, and you see over the page at 1017, it's the next tab. Next,
sorry,
next tab.
107?
Yes, next tab, please.
Okay. 37.
Dr. Adele, sorry, if you could just keep up a little bit. And it's paragraph 3, mixed use. This is a response from the DIFC the following day. And they say TPM mentioned in the meeting held that the agreed mixed use with DIFC management is different from the mixed use in DIFC plot guidelines. TPM is requested to show the agreement. Otherwise, the mixed use will be the same as per the master plan guidelines. So they come back to you and they say, we don't know, where's the agreement? Otherwise, we're going to have to stick to the master plan. There's no delay in that response, is there?
In that particular response, there is no delay. But if you look at the 4 points, okay, in that letter, which I know Mr. Bishir al-Baghazi is referring to, none of them materialized.
Well, I'm just asking you about this, Dr. Adele. I know you keep trying to change the subject. I'm just asking you quite specific questions about the mixed use, because that is what you were talking about in your witness statement.
Fine, mixed use. Okay, did it stay the same? He's
Well,
asking me about agreement. I don't have an agreement. The agreement is verbal between 2 parties. So I don't have an agreement. Otherwise, he's telling me to stick the mixed use. Whereas CHL are telling me, no, we've agreed a different mixed use.
Now, at this stage, there is a plan to use. Was there a plan at this stage to use automated parking for the offices?
Yeah, with the 88%, 75, you would need APS, automated parking system. And I know that CHL and Cayman, both of them are not desirous of having this, even though I had an experience in the IFC with the building parliament for building APS, which is good. But both of them, they did not want the APS. So if you have for this mix, 88, 75, obviously you would need APS, otherwise you'll go to the 6th basement, which is not possible.
Dr. Adele, again, I'm going to have to ask you just to slow down a little bit, because I can see the stenographer is really struggling to hear some of your words, I'm afraid. It's not your fault. I know it's difficult. One of the things I did not hear is that you said both of them did not want the automated parking system. Who were both of them?
DIFC and CHL, both of them were not desirous of having automated parking system, APS.
All right. So both parties realise that the mixed use has got to change from the 88% that you were proposing anyway.
Yes, and you know, further to that, so we requested the consultant to look for a mix to eliminate the APS.
Yes, and I think we see it actually in your witness statement. If you've got, that's probably the easiest place to see it. It's in paragraph 49 of your statement. Do you have that?
Yes.
Yes, so paragraph 49, on the 7th of September, Dewan sent me the parking summary for the project. He said that based on their preliminary analysis, the mixed use of 52% office, 32% residential and 5% retail was required to eliminate it, automated parking. So the result is that the mixed use that you thought had been agreed was going to have to change anyway.
Yes. By the way, they made a mistake in forwarding this, the consultant. So they sent us the correct one, which is 66 29.5. And in one of my letters, I've mentioned this.
All right, so hang on, I'll come back to that. 66.26.5, you say.
29.5.
29, thank you. So, but at this stage, all of this discussion about whether or not there was some agreement to an 88% office mixed use is rather irrelevant to the progress of the project, isn't it? Because you've just discovered that you need an entirely new mixed use from that as well.
Well, this happened during the meeting, and I think it's minuted that both CHL and the IFC said that they want APS. So what is the way forward? Is to go for a mix that will eliminate, this is what they asked me to do, request the consultants, a mixed use, which will eliminate the APS.
All right, that's on the 7th of September you received that information that the mixed use has to change. Can I ask you to go forward, please, in the bundle to page 1130? Tab 147, please.
So, sorry, which one is that?
Tab 147. I'm sorry, you've got to go into bundle 3, volume 3, thank you. Need volume 3, Dr. Adele. There should be someone there helping you. Hopefully they'll be able to find the right volume for you.
Volume 3.
What's the tab? 147 is the tab number, thank you.
Yeah. No, there is no document.
Yes, you have it.
No. So this is volume 3 of 5.
Yeah, that should be right. You should be looking for page 1130.
1130.
I think the agreement was that there would be use of the case line system. Unfortunately, I don't think Dr. Adele has a separate screen.
No 1130 here, sir.
Tab 147, Dr. Adele.
Do you have tab numbers?
Yeah. This is starts from 153.
You may have different. Yeah. So it sounds like your volumes are organised differently. So we are in volume.
Are you talking about my email on 8th of September?
1130, please. 1130. Look at the bottom right. You will see a number.
Okay.
If the associate could actually find the page, that might be quicker.
Yes.
Thank you.
Okay, I found it.
The letter is dated 16th of September 2008.
Yeah.
Yeah, and this looks like a letter from TPM to the DIFC, yes?
Yes, that's right.
All right, and do you see under the heading mixed use?
Yeah.
Yeah, so you say the mixed use of 88% offices, 7% residential and 5% retail was touched upon during a meeting held on the 1st of September. This mixed use is currently under consideration with the aim of reaching the optimum mix, which is to avail the maximum benefit for both DIFC and CHL, taking into consideration the need for automated car parking system. Following confirmation by the consultants in their emails of 7th and 8th September 2008, that in order to eliminate the automated parking system, the mix has to be 52% offices, 43% residential and 5% retail. Please confirm that the above mentioned mix of 88% offices, 7% residential and 5% retail is acceptable. So what happened, it seems, is that you are told that your 88% offices plan will require automated parking, and you know that the DAFC doesn't want automated parking, and you know also that CHL doesn't want automated parking, but nevertheless, TPM keeps asking for the same use mix. That's what's happening here, isn't it?
Yeah, to be honest with you, I can't recall why I have written this. I don't know why.
Well, in fairness, I don't think you signed the letter. It's signed by Mr. Gathbar. You see over the page.
Yeah, but usually these letters get drafted by me.
So you think you would have drafted the letter?
I can't confirm, but
well, the DIFC, you can see how that might have wasted a bit of time in the discussions, though, can't you?
yes, I can. Indeed. It is a bit confusing. I can't recall why it is written this way. Sorry.
And then on page 1379, which is tab, I think it's 136, is it? Sorry, tab 159 we're looking for, please. You may find it's in the next bundle, Dr. Adil, but I'm not sure because your bundles are organised differently. Could I just, okay. 159, thank you.
159.
37.
No. 28th of October?
Yes. So they come back and they reject the request for 88% officers again, and they say the mixed use is going to be as per the master plan. And as far as you're aware, there's no discussion between those two letters about some other mixed use, namely 52% officers, which would be required to eliminate parking. As far as you're aware, there's no discussions between these two times.
I can't recall this.
All right. But it looks like a bit of delay is being caused by negotiating about a mixed use that you no longer really want.
You can work out the delay and put it on our account, TPM account, compared to the overall delay.
All right. So then you have a meeting with the DIFC, and if we go forward to page 1387, tab 162, please.
Okay.
And then it looks like you were at this meeting. Do you recall it? It's on the 5th of November 2008.
Yes.
You recall the meeting, or you actually sitting here today? You can't recall. Thank you. All right.
I'm looking at the minutes and.
Yes. And if you look at it, line 1.1, AJ, that's you, explained TPM and Tamniat's position that they are requesting a variation from the current product mix in the DIFC guidelines to 29% residential, 66% office, and 5% retail. The response 1.3, do you see the second half of it? NMN explained that the current mix is a result of the master plan study, and that any variation from that has to be accompanied by a study as it related to the master plan, and that it would require a final approval by DIFC management. And then 1.4, you say that the studies have been done by Tamniat showed that the requested mix would make for a more functionally and financially feasible project. Just pausing there, you hadn't at that point actually undertaken a financial feasibility study for the mix that you are proposing here, had you?
Not as TPM, but it was carried out by Mr. Abdel Samir Al-Fadl, and it was reported that this mix will give more benefit to the partners by 12% extra profit.
So you say Mr. El Fadl had undertaken a study for a mixed use of that nature, 66%, 29%, and 5%.
Yeah, that is minuted, by the way, somewhere, I think, or this is in the presentation that we gave to the
We'll take that up with him perhaps, but at 1.5 it says MN, which is Mr. Mohammed Yusuf Al-Najjar from the DIFC. He agreed to re-escalate the issue with DIFC management and support it with the outcome of his technical evaluation together with a report on buildings architectural feasibility to be submitted by Tamniat. MN stated that he cannot commit to any time frame for review of this study, nor can he commit if it will be approved by DIFC management. So at this point, you knew that it would take time to get a variation from the DIFC master plan, yes?
Yeah, but you don't usually give open-ended dates. We don't know how long it will take. You usually say it will take a week, it will take days, it will take months. But here I cannot commit to a date, and I don't think this is very helpful.
Yes, but you don't go back to him at that stage and say, well, we just can't wait that long because we have to get on with the design, for example.
Yeah, we must have done this. And I must have written as well that it is at some stage to the client that, this statement, the open-ended date is not very helpful. I'm sure there is something to this effect.
He was also telling you that he couldn't give you any promises that it would be approved. So he was telling you that it was uncertain. Is it fair to say that at this point it was more important to you to get the mixed use that you were asking for than to get the issue resolved immediately?
Sorry, can you repeat the question?
Was it more important to you to get the mixed use that you wanted than to get a mixed use agreed and to move the project forward?
I think it's important to get this particular mixed use where we have it's more profitable. That is closer to the original master plan because the 88 is far away from the original master plan mix, so to be approved. So I would like this particular one to be approved at that stage. This is the logic.
Yes, but I'm asking you in the order of priorities. In the order of priorities, you're saying agreeing of the mixed use was slowing down the project, causing delay. But from your perspective, the mixed use that you were asking for was more important than the delay that you say was caused by all these discussions.
We're looking at things on hindsight. And maybe at the time when I knew that it's going to take that long, I would have made a different recommendation. But at that stage, no, the mixed use was important, and we wanted it to get approved by the IFC.
And then they come back and they reject that, don't they? In December, I think these documents are out of order. Bear with me 1 second, sorry. And then if you go forward in the bundle, please, to page F1418.
Yes.
You have that. So that's a letter from TPM, and this is on the 10th of November now, and it's the subject desired mixed use. So again, this is likely to be this is in fact a letter that you signed. and you refer to the meeting on a meeting on the 28th of October 2008, and then you go down to the third. If we look at the third paragraph, you say, as it was explained to you during the said meeting, the client was banking on a mix of 88% 7 and 5, which is the mix the current pre-concept and concept designs are based on. However, following the presentation of the pre-concept at the DIFC on the 1st of September, it was clear that DIFC prefers not to have automated parking system. And you've agreed, you've confirmed that actually that was concept's position as well. They didn't want APS, yes?
Yes, correct.
So the consultants were therefore requested to carry out an exercise to increase the percentage of the residential on the account of the offices in order to eliminate the APS. And then it says immediately after completion of this exercise, TPM forwarded to DIFC these percentages, namely 66%, 29% and 5%, where the original offices percentage was dropped substantially. And then you say these are the desired percentages rather than the ones mentioned in the meeting, namely 34% offices, 52% residential, 7% hotel and 7% retail. It's clear that by having a hotel, the efficiency of the current design which is bound to drop, and then you ask for the mix of 66% formally in that letter of the 10th of November, and then you are told no about, what, 6 weeks later by the DIFC, and that's the previous one. So again, what is happening here is that you are simply making a proposal that the DIFC deviate from the master plan. They are continually saying no, and you are continually asking them again and again to do so. That's a fair characterization of what's happening here, isn't it?
No, I think I'll take you back that the DIFC dismissed was based on an agreement, I would say, at least in a meeting, okay, tell the consultants, and the two parties asked for this, the DIFC and CHL, okay, to give us a mix, which will eliminate APS.
I thought you said the agreement. Dr. Adel, if you keep pausing, I'm going to keep interrupting you, I'm afraid. Please carry on.
So, no, this is what I'm saying, is that there is minutes of meeting, I'm sure somewhere in these bundles, where DIFC and CHL instructed the consultants, either directly or through us if they were in the meeting, to find a mix which will eliminate APS. So the consultants came up with this mix, which means that the DIFC were also looking for a mix that will eliminate APS. Obviously, they did not ask for the mix just to see what it is. And, you know, this will lead to an approval of this mix.
Well, presumably they needed to see what mix would eliminate APS, such that they would then be able to take that to management and say, do we approve it or do we not approve it? That's what was happening there, right? Yeah, so there was no agreement between the DIFC and Concept for a mix at whatever the consultants came up with, was there?
No, what I'm saying is that there was a desire during the meeting to eliminate APS, and the consultants were instructed accordingly to find a mix which will eliminate APS. So whether they will, the guy who was sitting in the meeting from the IFC will take to a higher level to get it approved once the mix will be provided by the consultants, or he will say himself that this is okay, depends on his level of authority. That is something to be decided by the IFC, not me.
Yes, but at the meetings when you had those discussions, the people that you were dealing with had made it very clear that whatever the outcome, they could not guarantee that it would get approval from their management. It made that clear to you, hadn't they?
They have, and not only they made it clear in the meeting, there are a lot of correspondence, and we go one step forward, and then we get another letter from the IFC saying this is not approved or this is rejected, and we kept trying until in the end it was approved.
Thank you, Dr. Adel. My Lord, I'm aware it's probably time for a scheduled break for the stenographer. So you know I'm making reasonably good progress in terms of my notes.
Thank
All right.
you.
We'll take a 10-minute break then. Thank you very much.
Thank you.
Thank you.
My Lord, I don't see Mr. Williams yet. I don't know whether or not he's back.
I'm sure he's there somewhere. There he is.
There he is.
Good.
So I think we can go ahead. With your permission, my Lord, I'll carry on.
Please do.
Dr. Adel, so we got up to the end of 2008 and the discussions, and we saw that on the 24th of December, the DIFC had rejected the latest proposal for the mixed use, and there is then a further discussion in a meeting in February 2009 about the mixed use. Do you remember that?
The 25th of February meeting?
Yes.
Yeah, I remember the meeting, but I don't remember what was discussed, so I need to look at the minutes.
Yes, that's fine. Let me show you the minutes. If you go to, please, to page, I'm going to give you volume numbers. It's volume 3 for me at least, and it's page 1437.
Tab 179.
Which is tab 179.
Yep.
It actually starts at 1435, I'm sorry. So that's, you'll see the 25 February 2009 meeting, and you prepared the minutes, in fact.
Yep.
And if we go down to page 1437,
yeah,
you'll see there's discussion about the minutes, about the mixed use, and it starts at 411. There's discussion about the history of it. So the original design was prepared for a mix of 88% offices, and you say there's an understanding of an agreement. As this mix requires APS, DIFC requested the consultants to find a mix that eliminates it, and then the consultants came up with a mix of 66, 29, 5. And then paragraph 413, there's reference asking basically for the CHL would like DIFC to approve the mix with 66, 29 and 5. And then do you see at 414, it says DIFC requested CHL to come up with a commercial proposal for this mix. CHL stated that they'd already paid the price for such a change. And in addition, they're happy to give up the 12-metre wide road requested by RTA in return for approving the above mix. So at this stage, there was to be a commercial discussion about what CHL was going to offer in exchange for an amendment to the mixed use, yes?
Yes, that's what the minutes say.
And in the meeting, CHL offered to agree not to make a fuss about the road. But after the meeting, there was a further internal discussion, wasn't there, in CHL about what else might be offered to the DIFC to make this an attractive proposal for them. Do you remember that?
Sorry, can you just repeat again?
After the meeting,
Yes.
CHL, including you, had a discussion about what else you might offer the DIFC to make it attractive for them to agree to the mixed use that you wanted. Do you remember that?
Is that a post-meeting note?
I'll show you it in a moment, but I'm just asking what you remember.
Not really, I cannot remember, sorry.
All right, let me help you on that then. If we turn forward to page 1446, I assume it's 2 or 3 tabs on.
Tab 181.
Tab 181, thank you.
Okay. Yes.
So This is an email from Mr. Al-Fadil, but it is sent amongst others to Adele, which I assume is you, on the 28th of February 2009. Is that a fair assumption that went to you? You received that at the time?
Yeah, actually, this is what I referred to about the 12% increase in the first paragraph. So I said to you that there is a study from Mr. Al-Fadil stating that there will be an increase of AED 114 million on the net profit, representing 12% additional profit.
Yes.
Shown. So this is what I referred to earlier.
I see. And then there's a discussion as to how that additional profit ought to be shared, yes? Do you remember that?
Not really, no.
We can pick it up if you look about a third of the way down the paragraph. It says definitely, Smith start. Do you have that? It says definitely the impact will be much bigger and more positive. As such, and if we accept the proposal of DIFCI to increase their portion of such difference to 45%, then they will receive an additional amount of 11.4 million dirham, and their overall shareholding in the project will become 36%. And Tamniat and its partners will gain an additional amount of 102.6 million, and their overall shares will be 64%. However, I suggest to go back to them with one of the following counter offers, and then Mr. Al-Fadil suggests a counter offer. Offer them an additional 5% in the difference generated from changing the formula, 5.7 million dirhams, and their overall shareholding will be in that case 35.5%, or offer them the 10% that they've asked for, which would take the shareholding, as we've seen, up to 36%, but with a guarantee from them that there will be no deduction from the plot for the new road. So at this stage, your side, CHL side, is considering offering them between 0.5% and 1% more by way of shareholding in exchange for amending the mixed use, yes?
Sorry to just correct you. TBM is not part of these things, these discussions, most of the time. Yes, I attend, when I'm invited to, but these are internal discussions between, CHL, Tanmiyat people, because these are purely commercial, not technical.
I see. So you have nothing, you don't know anything about these commercial discussions?
These have no significance to us as TPM, when it comes to moving the project forward. I mean, the only thing is that we need to know what has been agreed, okay, and they tell us what has been agreed, and so that we take it and move forward.
Yes. All right. But then this email you receive on the 28th of February 2009, and then on the 25th of March 2009, the DIFC approved the mixed use that you wanted, didn't it?
Yes, I mean, they approved the mixed use we wanted, but I can't remember the date.
I understand. You can't remember the date, that's fair. But you don't know then, presumably you're not involved in the commercials, so you don't know what, if anything, CHL had to give up in exchange for agreement to the mixed use.
No, I don't think.
All right, I'll leave that there then. Now, throughout this period that we've just been looking at, so from July 2008 up to this period, March 2009, Perkins and Will had been trying to come up with a design, hadn't they?
Yes, indeed.
And they had prepared that design on the basis of the assumptions as to 88% offices for mixed use and 1.75 million square feet GFA, hadn't they?
Correct.
And the issues in relation to those points had not prevented them from progressing their concept designs at this stage, had they?
No. Based on these, on the details or information we've given them.
Yes.
So we have not changed these until a later stage, but they were progressing their design based on these assumptions. But of course, they could not apply for the NOCs and the permits from the authorities.
Of course, but you have to take it in stages, don't you? You need a proper concept that everyone is happy with before you're ever going to go forward and start applying for NOCs or take concrete steps like that. You need the concept design first, don't you?
Yes, thank you. And that is the argument I make to the statements that Mr. Bisher made against my statement. That you need to have a concept to go and ask for permissions and NOCs.
Yes.
You're saying, you know, the permissions, this goes at a later stage with this concept, which I disagree with.
Yes, all right. But the first attempt to produce a concept design was produced in September 2008, wasn't it?
And I think the first concept maybe 5th of October, the pre-concept is called, then 27th of October, because I can remember from the independent consultants reports, he has two reports, one dated 14th of October, and the second one is dated 6th of November. So the first one was about the pre-concept dated, I think, 5th of October, and the other one was about the rationale that was submitted on 27th of October, 2008.
All right. So just pausing there, though. So you say the concept designs were produced on the 5th of October, the pre-concept design.
Yeah.
Now, we've seen it, but the question of whether the agreement was for GFA or BUA, that had been resolved on the 29th of October 2008, hadn't it?
28th of October.
Well, the end of October. So,
Yeah.
So it had not prevented the designers from producing their pre-concept design, had it?
No, but remember, any changes to the mix, to the GFA, that will affect the pre-concept design. So they've continued based on this mix and this GFA. So the moment we change any of these, this will affect their design.
Well, the problems that you encountered with the design were rather more fundamental than that, weren't they? They didn't depend on the mix use or the GFA, did they?
I would say the mixed use, yes, because you know the offices would require more lifts, but the whole design is, which was, by the way, won a competition, and I don't know based on what criteria it won a competition, which was given to us by the IFC. Okay, the whole design, I think it was designed for a different plot. The splitting of the two towers, okay, and making the two towers in such a way to maximize the wind speed to generate electricity, okay, that made the whole design inefficient in a way and commercially infeasible.
Let's just take it in stages.
Okay.
The concerns about the feasibility of the design had nothing to do with the mixed use, did they?
Now just remember that the offices, okay, would require larger number of lifts because you have two peak hours in the morning, and most of the designers would, or most of the offices, top class offices, you won't wait more than 45 seconds for the lift. So that requires more lifts. So the mix, it affects that, and the number of lifts is required is more for the 88% 7.5.
Yes, but as I'm saying, of course, the actual mix use would affect some aspects of the efficiency, but your concerns with the design were more fundamental than that. You were concerned that whatever the mix use, this project wasn't going to work with this design, yes?
Yes, the splitting of the two towers, as I said, and having two cores, and they did not want to, move at the beginning into a single design, even though we came up with some ideas. They just wanted to keep it as it is, and if they're to change anything, then they will need compensation.
Who's they in this sentence?
Sorry?
Who's they?
The Perkins and Will and the UN.
Oh, I see. So Perkins and Will, you're not suggesting that the DIFC was insisting on a two-tower design?
No, but that two-tower design came from the DIFC. Obviously, they made a competition. It won a competition, and they gave it to CHL. Go with this with the award-winning design. We like it. Okay, so it doesn't need the approval that it usually requires when concept CHL brings a design and then it has to be approved by the IFC. This is already approved by the IFC and already liked by the IFC, and take it and run with it.
All right, but can I just ask you to look now at a letter that you wrote in November 2008? You'll find it in, well, it's in my volume 3, F volume 3, page 1391. Tab 164.
Yep.
So there's a letter from TPM, but you signed it. You can see that on the next page. So this is a letter from you, and you're writing to Dewan. So Dewan were partnered with Perkins and Will to produce the concept design, yes?
Correct.
And then if I just ask you to look at one particular paragraph, it's the final big paragraph on this page. No, same page, please don't turn over.
Okay.
I'll tell you if you need to turn over, don't worry. Final big paragraph on this page. As for the design parameters, and following the confirmation of a GFA of 1.75 million square feet by DIFC as was conveyed to you, please specify what other important items, apart from the mix, will significantly affect the current design. And then you say, keep in mind, however, that the real and fundamental issue at the moment is not in the parameters, but rather in the commercial feasibility of the project, which is purely a design matter. So it's right, isn't it, that in order to resolve these problems that you saw about the commercial feasibility of this design, it wasn't necessary to have the mixed use settled. That's true, isn't it?
At this stage, we are still in November, and we were hoping that the consultants, will be able to fix their design and give us the promised efficiency that the chairman asked for in the meeting of 31st of August. So we were still hoping we bring into the surface the problems with the design, the most important of which is the efficiency, but there are other issues with the design as well. And yes. So we're, this is, if you like, a letter to the designers to encourage them to really fix their design, because it's commercially infeasible.
Yes, and my point though is that your decision that the current design, or your view that the current design was commercially infeasible, would not be affected by any changes to the mixed use.
Perhaps not, other than to get the correct design for the right mix and the right GFA. So we will avoid any abortive work.
And for you, commercial feasibility meant 80% efficiency, yes?
80% efficiency, that was the request of the chairman. And that is minuted, as I said, in the meeting of 31st of August 2008.
Yes. So
the consultant really given us, 78, even 75, I would have gone, forward and tried to convince the client. But even when they say we're gonna give you 75% based on single tower and 68, based on twin tower, all of these are just, there is no design for this. This is an arithmetical, exercise they have done. If you lower the building, then obviously you will have, a bigger area, but lowering the building will compromise the iconic nature of the tower. And this is a must by the IFC. It has to be iconic.
Well, it was in fact the chairman's preference to keep 2 towers, wasn't it?
I don't know whether it is, his, obviously for any design and for any developer, the number one, I would say objective is to have a commercially feasible design. The chairman said 80%, but others said, we were nowhere near 80%, 49.9. And not only that, they have told us the design they submitted, they said this is 80 plus efficiency. And I said, what kind of calculation you've done? Because you can just look at the site plan and you see 40 to 45% of it is gone for lifts and other services. So then they said, this is how we work it out. No, this is not the way to work it out. Use the BOMA. Okay, the BOMA is a very well-known organization established in the States in 1907, and that it has a standard way of measuring efficiency. So just use that. When they used that, they came up with a 49.9, which was a disaster.
Dr. Adele.
I'm just rather interested in this, Mr. Montague-Smith. Sorry to interrupt.
Not at all.
How did they arrive at an 80% figure? What method did they use?
I think it's in the independent consultants report. Is that they use maybe the GFA and built-up area. The efficiency is very clear. Is the leasable, net leasable, or saleable area. Yes. So you don't include the shafts and other common areas.
No, all the common parts are excluded. Yeah.
Yeah, and not only that, they have given us the efficiency based on single tenant. Yeah. How on earth would anybody? I mean, all of us, have our offices. Our biggest office, and we are one of the 8th largest, project management company in America. Is the maximum office is 250, and when we grew up to so many people, we have 400 square meters. So who are these tenants who will have the whole floor?
Yes, quite. Of 2 towers.
Yes.
That's great. Yeah, sorry, Mr. Montague-Smith, I was just interested.
Yes, no, please. The observation I was going to make was actually that the question was actually about the source of the requirement that there be 2 towers. And the question was, it was in fact the chairman's preference to have 2 towers, wasn't it? Now, Dr. Adele, just before you embark on your answer, could I just ask you to think about the question and answer the question, only the question? Because your very long answer that you gave before the judge asked you a follow-up was not an answer to the question that I asked. So it was the chairman's preference to have 2 towers, wasn't it?
The chairman preference was to stick more or less to the original design, as I said, to avoid any further approvals by the IFC. So, and they promised him that they can give him the efficiency he's asking for with 2 towers. So obviously his preference became, that, okay, if you want to give us the 2 towers, and in, I think in a letter they wrote in 16th of December 2008, they said they will give this efficiency required by the client. Until now, I doubt. I don't know. Perkins & Will is one of the top consultants in the world, but what they have done will go as a black mark in their record. So the chairman's preference, and I tell you just one thing about the chairman when I had a meeting with him and I remember this vividly, with Hussein Shalkami and the chairman and myself in the Living Legends. And when we challenged Hussein Shalkami from Perkins and Will that, this is, what kind of design is this? Not giving us the efficiency we want. So Hussein Shalkami, but he said, but it is a nice tower, nice design. So chairman told him, but I'm not going to marry the tower. I want something which will give me, a revenue, a good revenue. So I don't think he has any, attachment to the design as such, other than to avoid further, approvals and starting again from scratch. This is in my opinion. I may be wrong, but this is what I think the reason for the chairman wanting the spirit of the original design. Now I know at the beginning they came up with this turbine, which we said from our experience, guys, you're not going to generate any, good electricity out of this. And then when they admitted to this, they kept the design as it is, even though it is, if you look at the plans, it is actually made in order to maximize the wind speed. So when they deleted the turbines, they left the design as it is, without making any effort to change the layout to maximize or to increase efficiency.
Right, so what's very clear is that you were unhappy with the performance of Perkins and Will. Presumably that came as a surprise to you because they were world-class consultants.
Yes, and they designed for us the building by the man, which we managed as Hill International at that time, and I was involved directly in it. So they are, good consultants. But after that, I don't know whether this is a secret or not. After that, what they have done with the PI01 project, after their performance there, I stopped recommending them.
I understand. So that, yeah, all right. Do you think, though, that if the project had moved from 2 towers to 1 tower, it might have helped them to achieve a better efficiency for the project?
Yes. One of my suggestions, and I'm not a designer, by the way, was to try and stick the 2 towers together, okay, with something with the cladding which is different to the cladding of the proposed by them, which is onyx. Again, is very expensive, and glass, and make the core one single core for the 2 towers. So we still have the spirit of the 2 towers. Okay, you make something dark, for instance, in the middle, but you have the core there in order to have 1 core instead of 2 cores, which really, reduced dramatically the design. And I think I even asked I tried to find I had an AutoCAD operator and asked him to do something for me at that time, just to show them that we can do this, but they did not want to do anything. Anything they want to do, well, it will be at cost. Yes, we can design single tower, but this will be, you pay us 495,000.
Yes, so they were going to charge you again to produce a revised design to try to solve this problem. Do you think, though, that actually the problem might not have been with Perkins and Will, the problem might have been with the combined demands of 80% efficiency and 2 towers?
This was made clear at the beginning in August. So the consultants with, caliber like Perkins and Will should have known this from, I wouldn't say day one.
Sorry, Dr. Adil, that's not the question. And I understand your point about they said they could do it, but then they couldn't do it. My question's about the end of that part of it, which is, do you actually think in your mind that the reason why it couldn't be achieved was because actually the efficiency requirement of 80% was incompatible with the 2 tower building?
Yes, 2 tower building, definitely. I think it will be very difficult to achieve 80%. Okay, but when I said that, we suggested to have the core in the middle, keep the same spirit, but have the core in the middle, instead of two cores for each. They never took this seriously. And as I said, they did not want to do anything.
I see.
But remember, as I said, this is all, you know, and I know you don't like this, but I'm going to tell you again and again, this design is award-winning design. It won a competition. I don't know the criteria for winning the competition, but it came to us from the IFC and wanted to please the IFC by having the same towers that they liked.
Well, you said that several times, and I understand your position in relation to that, and no doubt we'll have submissions about it. But you understand your job is not to make submissions. Your job is to just give evidence and answer the questions. So that's why it's not that I don't like the answer. It is that it's not an answer to my questions. So I'm just going to ask you to. I've only got a few more questions for you, Dr. Adil, and so I'm going to move on to a different topic, if I may, unless, my lord, you look like you might have a question on this topic. But
it's only curiosity. So
no. Well, we've got time in the timetable, so do please indulge.
Well, I think from looking at the various presentations that were given of slides, that from this point on, you were always looking at one tower, not two. Is that right?
Sorry, Sir Jeremy. Sorry, I did not understand the question.
After you had terminated Perkins and
yes,
from that point on, any new designer you were contemplating using, you were always thinking of one tower, not two.
Absolutely. And actually, we brought CSI on 27th of August 2009, and they presented a single tower.
Yeah, I've seen the pictures in your slides, the presentation slides. They're all very impressive, but it's one tower, not two.
To make them work, that is, you know, more hard work.
Yes, indeed.
And CSI were never actually appointed as a consultant to develop a design for this project, though, were they?
No, they were not, because we did not have any answer, either yes or no, or find an alternative, or we like it or we don't like it, from the IFC. And I disagree again with Mr. Bush's statement, saying that until he left, end of 2009, CHL did not come up with any alternative. We actually came with an alternative, but we had no answer from the IFC.
All right, well, I'll come back to the design from CSI in a minute, but just let's go back into the chronology, if we may. You mentioned that they were terminated in June 2009. Now, by this point, you were not thinking about the sort of nitty-gritty of construction, like obtaining construction permits. That was not something that you needed to do by the middle of June 2009.
Yeah, June 2009 was obviously the termination. It wasn't an easy decision. We tried to the last minute, try and make things work, try to convince the consultant. So at that moment in time, obviously we were looking for a different designer and different design.
So you weren't trying at that stage to obtain construction permits for excavation, for example?
How can we do that if we don't have an approved design? We cannot.
Yes, so you weren't?
No.
Yeah. So if you go to paragraph 56 of your witness statement. You have your witness statement, it's bundle D, tab 5, page 117.
Sorry, Mr. Tom, can I ask you to just repeat?
Yeah, of course. Tab 5, it should be your witness statement, and page 117 of the bundle is paragraph 56.
Okay. Yes.
And do you see there, you're talking about a meeting that you had sometime before the period we've been discussing, 21st of September 2008, with Dewan and Perkins and Will. And you say at the meeting, Dewan reiterated to me just how important it was to get the affection plan. Without it, we could not obtain the excavation permits needed to start the actual construction work. But at this time, you were nowhere near needing to obtain construction permits, were you?
Sorry, you're talking about a year difference. You took me to June 2009.
Yeah.
Now you're bringing me back to September 2008. Is that intentional or yeah?
Yeah. So but in September 2008, in June 2009, throughout this project, you were never in a position to apply for excavation permits, were you?
When we have the faction plan, when we have the right concept, okay, then we can apply for permissions, but we don't have either.
So you received the affection plan in April 2009, yes?
Yes.
So there's no sense in which delays in relation to the affection plan delayed the applications for excavation permits, is there?
I'm not sure I understand your question, but if you're saying that we could not have started the excavation, then you're right. We cannot start excavation unless we have permits from the authorities. And to have permits, we need, as I said, a faction plan and a design.
Yes. So my point is that when you read this paragraph of your statement, it makes it look like you're complaining that delays in relation to the affection plan had delayed applications for excavation permits. But that's not the position, is it? It didn't delay applications for excavation permits, did it?
If we have the affection plan and we have a design, okay, then the consultants will start applying for the NOCs.
All right. Just finally on Perkins and Will, please.
Yes.
Paragraph 85 of your statement. You talk about in the middle of that paragraph 85. Do you have it? You say we paid Dewan and P&W in good faith a total amount of 3 million dirham. Yes. Yes. You see that. Now, in fact, they invoiced you for more than that, didn't they? They invoiced you for 4 million dirham.
Yeah. The payment schedule is that we pay them 5% on mobilization and 5% on the completion of the concept. So we have paid both of them mobilization, and then maybe it's been my fault that because Perkins and Will promised that they will fix the design. Okay, just give us the 5% for the concept, we'll fix the design. We paid them the other 5%. But at the same time, D1 submitted their invoice and we did not give them anything because they were acting just like a postman. So that's the reason why, we paid 10% to Perkins and Will, okay, for mobilization and concept, whereas for D1 only 5% for mobilization.
I see, but so there was a sum, as I understand it, of about 1.3 million dirham, which you had been invoiced by Dewan, but which had not been paid. Yes.
Yeah. How can we pay for? We should not have even paid the 5% for Perkins and Will. It was my fault that I recommended payment.
And you felt that you should not have paid the sum for Perkins and Will because the money that was spent on those designs was completely wasted.
Exactly. We just had some, colorful papers that we cannot do anything with them.
All right. Just a few more issues I'd like to touch on with you, if I may. If we go to in your statement to paragraph 34, it's on page 189 of the bundle.
Yes.
Now, you're talking there about discussions for the incorporation of the joint venture company. I assume you weren't involved in those discussions, were you?
At that stage, I was informed, what happens in these discussions, and I think I was party to some of these discussions, and that's why I've written a letter on maybe end of March confirming what is being agreed. And I attended the 25th of February and 25th of March, I think, meetings from memory.
All right. But then just to deal then with one thing that you say in this in this paragraph, do you see about 6 lines down, you talk about draft, or 5 lines down, draft JV company articles of association, and then you say sent by Hexagon's then legal representative, Mr. Ashish Mehta. In fact, Mr. Mehta was acting on behalf of Concept Holdings, not Hexagon, wasn't he?
I know Mr. Ashish Mehta, and I don't know who he was representing, but I know he's representing Sheikh Cayman and Abdullah Al-Majid.
Yes.
So,
as to which entity he had a formal contract with to provide representation, you don't know.
I don't really know. No.
Thank you. All right, and then I think finally I'd like to come back to you about this issue of CSI, if I may. So you said, you referred to it in your evidence as well. You talk about a design concept presented to the DIFC, and you say on the 27th of August 2009. Now, as the judge asked you about this, the concept was for a single tower, yes?
Yes.
We've talked about whether a single tower would be acceptable or dual tower would be a requirement. But I think, would you disagree then with Mr. El-Fadel that his view was that a single tower would not be acceptable?
I don't know where he's coming from, but we proved beyond any doubt that the splitting the cores into 2 for the mix and GFA, it will not give you the efficiency you need. I really encourage asking the technical people to answer technical questions and the legal and to answer those questions.
If I'm asking you questions you don't know the answers to, please just say, and then we'll move through this much faster. That's fine. Now, did you know about any of the commercial discussions between CSI and Concepts that were going on at that stage?
I met the guy responsible for CSI, but to be honest with you, I cannot remember exactly, the commercial terms discussed at that time.
I see. Did you?
All I know, they were very keen to work on the project and, to do the concepts themselves from their offices in China or Hong Kong, and then even finance the project. They offered, to really be involved heavily in the project.
They offered.
This is a profitable project. We want to be a part of it.
Are you suggesting they offered to finance the project?
I don't know whether they offered to finance the project or not, but I know they were very keen to work on this project and be part of it because they thought this is a very profitable project.
And did you know that they were supposed to produce a funding structure to support their involvement in the project?
This is mentioned either in my, I think, in the statement or in one of the documents. They have offered to fund the project, yes.
But they never produced a funding structure, did they? As far as you're aware?
As far as I'm aware, no, I haven't seen any funding structure from their side.
And for that reason, their involvement was terminated, wasn't it?
I don't know the nature of the termination because they were also involved in the Living Legends. So I'm not sure why they were terminated.
Do you know when they were terminated?
Not really, but I seem to remember, I think it may be in the presentation or there is a date that CSI were terminated.
Well, I haven't seen a date, but we can look at it. We can look for it if it's there. We'll find it, no doubt. But you don't know when they were terminated.
Not really, not exactly. I mean, I'm sure there is something in these documents which shows when they were terminated.
Thank you, Dr. Adel. Would you just wait there for just one moment? I'm just going to check. Thank you for your patience, Dr. Adel. Thank you, my lord. Those are my questions.
Yes, thank you. Mr. Williams, any re-examination?
Just some questions, my lord. Dr. Adel, I've just going to ask you some questions in relation to some of the topics you asked questions about by Mr. Montague-Smith. Same process, listen to the question and take time to answer so that the transcriber can get it all down. You asked some questions about GFA and BUA in your testimony yesterday evening. Can you tell me what the industry definition of GFA is?
Okay. If you look at the authorities in Dubai, the IFC, TCOM, Dubai Land, Dubai Municipality, they will have different definitions for GFA and built-up area, and even the consultants the cost consultants who need to look at and produce the BOQs, they look at the regulation of each authority. So this is not, I mean, if you look at the one page that I've attached to my email to Sheikh Suleiman to tell him what is the difference between GFA and build-up area. GFA includes lots of things, but doesn't include, for instance, the car parking. Some authorities will say anything not air-conditioned, it is not GFA. Okay, it is built-up area. For instance, the staircases, the car parking, the other service rooms, and the rooms for the chillers. All of these places are not considered to be GFA. So it depends really on the authority. The GFI have a very good definition of GFA and built-up area, and I've attached this to one of my emails to Sheikh Suleiman.
You were taken to a document which is in the J bundle. Can I just ask you to take up the J bundle, please, and tab 2? Tab 2, page 27, and it's the joint venture amendment agreement.
Sorry, Mr. Williams, but we seem to be.
Is it?
Bundle J. Tab 2, page 27, joint venture amendment agreement. And Mr. Montague-Smith was showing you yesterday evening clause 2.23, which is the minimum total built-up area for the project land in this agreement, 1.45 million square feet. I want to ask you about clause 221, just above it, where it says the purchase price for the project land shall be based upon the total built-up area of the project, brackets excluding parking, and shall be 145 million dirham based upon the minimum total built-up area of the project land indicated below. My question is, in terms of the definition of GFA and BUA that you just discussed, this description, total built-up area of project excluding parking, where does that fit in terms of those industry definitions?
It excludes parking, but there are other items other than parking, including the build-up area. For instance, if you have a balcony, not air-conditioned, not within, then it will be considered as BUI, but not GFA. Can I have the email I've sent to Sheikh Suleiman? Can I have exhibit 1?
I think the document that the witness is asking for is bundle F, page 1019, I believe. It should be in volume 2, tab 138.
Volume 2. It's one of the first. Just give me the exhibit and I'll. I need the notes. Sorry, gentlemen, I'm looking for one piece of paper that I attached to my email to.
I think it'll be on page F 1019, the tab 138.
It's an email with one single page. Yeah, this one. You see, if you look at just accountable GFA excludes car parking areas, including driveways and ramps together, with pedestrian access corridors, lift lobbies, and ventilation plants exclusively, servicing the parking areas, lift machine rooms, plant rooms, store rooms, tank rooms, switch rooms, equipment rooms, and the like. But I wanted to tell you about the balconies. I'm sure it should be written somewhere here. You see, areas external to the building, including roof terraces, balconies, and covered walkways. So even though you put a balcony, but this is not GFA, it is built-up area.
Okay, that's helpful. And
yeah.
So my question is, by reference to this type of criteria that you're just showing us, the description in the JV Amendment Agreement of total built-up area excluding parking, is that usual or unusual in your experience as a definition to use?
I don't know why it's excluding parking, to be honest with you, because build-up area is usually includes parking. Build-up area is build-up area, as I said. And this is the QS's work out the build-up area. Each one obviously has its rate. I've never seen it excluded elsewhere, by the way.
Okay. And in your experience as a technical person, why is it critical?
I hesitate to interrupt, my lord. I mean, this line of questioning appears to be treating Dr. Adel as an expert witness. You can ask the question, we can make submissions on it later, but it does occur to me that we are not making productive use of time here.
Well, up to you, Mr. Williams, if you want to persist with the question.
Yes, I understood Mr. Montague-Smith's point. Let me ask the question like this: as a technical person, why was it critical to you, bearing in mind that commercial or legal people may use the term GFA and BUA in ways that doesn't necessarily convey the meaning that a technical person would understand? Why was it critical to you in pursuing this project to understand between the parties what exactly they meant when they'd agreed in the 2008 Amendment Agreement 1.75 million square foot BUA?
It is important, as I said, to see what was the intent, when the agreement was signed between the two parties, what they actually agreed upon, and whether there were some agreements between them after signing the agreement. Because I know there is a huge difference between having 1.75 GFA and build-up area. They are totally different things. So, but as I said to Mr. Tom earlier, is that I was working based on the understanding from, I'm sure, the chairman of CHL, as well as the documents given before I came on board, that it was 1.35 GFA. Whether this has been agreed verbally or in writing somehow, I am not sure. However, it will not be logical for anybody to instruct a designer to go with something that he knows it will change at a later stage.
Thank you. I would like to ask you just one more series of questions on a document you were shown by Mr. Montague Smith. And so could I ask you just to take up the F bundle, volume 2 of the F bundle, tab 120.
No? 120?
Yeah. So you should have page 921.
Yes.
At the bottom of that, do you see an email that's Tuesday, May 13, 2008?
Yes.
So that was the email Mr. Montague Smith had shown you, where the DIFC wrote to Mr. Suleiman confirming that the mixed use for the plot was as per the DIFC master plan. And I think Mr. Montague Smith had shown you a different version of this email that appears in the tab before, 119. But this version has Mr. Suleiman's actual response to the DIFC in relation to this. And my first question is, were you aware of Mr. Suleiman's response that appears above this email on page 921?
I have seen it, but I can't remember whether. Obviously, this is before my time, but I've seen this email before. I know Mr. Shahab's email created some frustration with Mr. Abdullah and the chairman. As I said, this is before my time.
Yeah, and what, if any, recollections of this email? Let me ask you another way. In your evidence, you stated that your understanding was that Mr. Suleiman and Mr. Vischer had reached an agreement on a mixed use that was different from that in the DIFC master plan.
Yeah.
And I'm interested in what your recollections are about the final sentence of this email, and unfortunately what you sent is far away of our goal and agreed with the DIFC.
This here it says Mr. Vischer and myself met many times just to finalize the mixed use percentage, which has been sent to the DIFC a long time ago. So it must have been sent to the DIFC. I don't know. I haven't seen such whether by email, whether by letter, or what. So obviously there was a mixed use. I mean, why would they agree to a mixed use unless it is different to what is in the master plan?
Okay, but that you have no other direct knowledge or recollection of this. Okay, thank you, Dr. Adele. I've got no further questions, my lord.
Thank you very much. Those are all the questions for you, so you're free to go. Thank you for your help.
Thank you very much, gentlemen. Thank you.
Dr. Adele.
Right, where do we go from here?
My lord, our next witness, Mr. Elfadil, he's testifying from a law firm in Bahrain, and I gather there are some technical issues that we're attempting to resolve, and we wonder whether it might be more efficient to take the lunch break early so that those can be resolved and tested, and that we're good to go thereafter.
Yes, well, it would certainly help to get matters resolved before. Are any problems anticipated?
Allow me just to check with my team whether they can connect now. No, I'm told they've attempted to connect and they've connected, but there are sound issues that they need more time to resolve. We can only apologise to the court. We wouldn't want to start him and then have to stop.
No.
We're pretty confident if we have the extra time we can resolve it and then not have intermittent.
Okay, what time do you start?
Should we take the usual 45-minute lunch break?
Yeah. Tell me when that takes us to.
Takes us to
22.
Yeah.
What?
Takes us to, I think, 20 past 1.
1:22.
12:22 in London time.
Yes.
Very good. 12:20 will resume. Thank you very much.
Thank you.
Thank you.
Good afternoon, Mr. Elfadil. My lord, are we okay to proceed?
Yes, please.
Mr. Elfadil, can I just check that on the screen in front of you, you can see, in addition to myself, Sir Jeremy Cooke and Tom Montague Smith QC?
Yes, sir.
Thank you. Can you confirm your full name and business address, please?
Okay. My name is Abdul Sami Al Fadil Hamid, and currently I live in 10010 Hosted Drive, that's Swanee, Georgia 30026.
Thank you. And I understand you were just completing your prayers. If you need to break to pray again, can you please let us know?
Yes, it's going to be around about 2.5 hours to 3 hours. I can extend it to 3 hours. Then I need to do another prayer because it's prayer time.
Okay, thank you. And I'd just like to confirm what and who are in the room with you. So you have two screens in front of you, one showing a visual of the judge and Mr. Montague Smith and myself. The other will display documents. Is that correct?
Yes, sir.
And do you have any personal devices on you, phones or laptops?
No, I'm using a laptop and a screen also. I'm not using my personal. I can put them aside.
Okay, so they're aside, they're turned off and aside.
Can you make sure
just a notepad in front of me? Shall I keep it or leave it?
You should leave it. Okay. You should leave the notepad and you should turn your phone off, please.
Yes, sir.
And is the only person present with you in the room an associate from the law firm, Yasmin Katani?
Yes, sir.
And you understand that Ms. Katani's presence in the room is to assist you to locate documents in the trial bundles which are in the room, and not to assist you in answering any of Mr. Montague-Smith's questions?
Yes, sir.
And the trial bundle in the room, those are the only documents in the room with you, and they're unmarked, is that correct?
Except with the Quran.
Yes, very good. Shall we administer the oath now, my lord?
Well, I just wondered, I may be asking for the impossible, but the way the lighting is in your room, Mr. El-Fadil, means that I can't really see your face. I can see you silhouetted. But I'd like to see your handsome face if I may. Is there any way the lighting can stop?
Is it better now, sir?
No, your facial features are hidden. Ah, that's slightly better. Ah, that's
Okay.
much better. Yes.
Okay, I just had to with the.
Yes. No, that's okay. Thank you very much.
You're welcome.
All right. Shall we administer the oath then, Mr. Williams?
Yes, Registrar.
Thank you.
Good afternoon, Mr. Abdel Fadil. Can you please state your full name?
Abdul Sami Al-Fadil Hamid.
Would you please confirm that you have the Quran in front of you?
Yes, ma'am, I have it.
Please repeat after me. I swear by Almighty God.
I swear by Almighty God.
To say the truth.
To say the truth.
And nothing but the truth.
And nothing but the truth.
Thank you.
You're welcome.
Mr. El-Fadil, can I ask you to take up bundle D, please, which is the witness statements bundle?
Okay.
Tab 3. Page 47. Have you got that? When you're answering the question, can I just ask you to say, yes or no, so the transcriber can get it, please?
Yes, sir. I got the statement right in front of me.
Yeah, what document is that? Can you read the title?
Okay, it says first witness statement of Abdul Sami Al-Fadil.
Thank you. And can you turn to the last page? That's page 63, please.
Yes, sir.
Is that your signature?
Yes, sir. This is my signature.
Are the contents of this statement true to the best of your knowledge and belief?
Yes, sir.
Thank you. Mr. Montague-Smith, QC, represents the defendants and he has some questions for you.
Okay, sir.
Good afternoon, Mr. Fadil.
Good afternoon, sir.
Good afternoon. I'll be the one asking you questions as we go forward. Can I just ask you this, though? When you give your answers, could you try to do your best to speak as clearly as you can and try and keep your answers quite slow? Because the technology that we're using, it makes it quite hard sometimes to hear, and we've had a few difficulties in the morning. So if you give it your best, I'm sure we'll get through it. Thank you. As you know, I'm going to be asking you a few questions about a project to develop some land in the DIFC. And you got involved in that project in early 2009, didn't you?
That's true, sir. Correct.
Yes. And so by this point, you must have been aware of the global financial crisis that was going on in the United States.
Yeah, it was just started at that time.
Well, it started, didn't it, in March 2008, so about a year before.
Well, yes.
In America.
By the time I was there, 2009, there was a global financial crisis.
Yes. So would you say that the impact of the events in the United States had started to be felt from the very beginning of your involvement in the project?
Could you repeat that, sir?
Would you say that from the beginning of your involvement in the project, the impact of the global financial crisis had started to be felt in Dubai?
I cannot confirm that. However, with the beginning of because when I joined was the early January, and we start to hear news. However, it's not yet fully impacted.
I see. And so the full impact began to be felt through the course of 2009, in your view?
The second half of the 2009, yes.
The second half, I understand. All right, thank you. Now, you, in your statement, you talk about a meeting that you had at the beginning of your involvement when you met with Mr. Ferouz. Do you remember that?
Yes, I have more than one meeting with Mr. Ferouz.
Yes, but so you said you had a meeting with the governor early in 2009, and then you talk about a meeting with Mr. Hadif Ferouz, the DIFC legal counsel at the time. And I'm just looking at, do you want to look at paragraph 10 of your statement, just to show you what I'm talking about?
Okay.
Paragraph 10, page D50. Do you see, you say, I met with Mr. Ferouz, I first met with Mr. Ferouz in March 2009. Now, before that, you had a meeting with Mr. Mushwa, Mr. George Mushwa, hadn't you?
Yes, sir. But the one I referred to was the meeting with Mr. Omar bin Suleiman and Mr. Mushwa. However, Mr. Ferouz was attending that meeting, the one I'm referring to in the beginning of this paragraph 10. Mr. Ferouz was there in the meeting.
I see. And do you remember when that meeting was?
Not quite sure, but should be either in February or end of January. I can't recall it right now, but it should be not later than February.
I see. And you think that Mr. Ferouz was there, but sitting here today now, just reflecting back to that meeting, how much of it, can you actually remember being in that meeting?
Yes, sir. That was my first meeting with the DFC officers and managers.
So in your statement on the third line, you say, I do not recall the details of that meeting.
Yes, sir. I don't recall the exact detail, but I recall being in the meeting. Yes, sir.
I see. Right. So you can't necessarily remember precisely what was said to whom by whom and things like that.
I cannot record every detail of it, but the nutshell of the meeting, yes, I recall it.
And do you have bundle F in front of you? If somebody could pass you, please, volume 3 of bundle F.
Is it F like in Frank?
Yes, F. Yes, we're going to be looking at bundle documents in the F bundle.
Okay, bundle F.
And it's tab 180 if you've got tabs.
180. Okay. Yes, sir.
Yes, all right, so you've got that. So do you see there minutes of a meeting 25th February 2009?
Correct.
And do you see Mr. Mushwar is there? And Mr. El Fadl, you are listed there as number 7 on the attendance list.
Do
you think this is the meeting that you are referring to?
No, sir, because this meeting doesn't have Mr. Omar bin Suleiman on it.
Oh, I see. Yes. No, but in your witness statement, you say you met Dr. Omar bin Suleiman in early 2009, and then you say, I also recall separately meeting with Mr. George Mouchouar.
Yes, on a separate meeting, but you asked me about the meeting of Omar bin Suleiman.
No, I was asking you about meeting. Oh, I see. Yes, you're right. That's fair. All right. Now, let me let me ask you then about this separate meeting with Mr. Mouchouar. This is the 25 February 2009 meeting, the one that we're looking at the minutes for.
Yes, on number 10, my statement, I said I don't recall the detail of that meeting.
Yes, but we discussed this meeting, the one that you had with Mr. Mouchouar. You recall being there or not?
Okay, so let's be clear here. First, you asked me about the meeting with His Excellency the Governor, and you asked me about whether I would remember that, and that's what my answer was. Now, yes. You asked me another question about Mr. George Mouchouar meeting, correct?
Yes.
Okay, I don't recall exactly the detail of that meeting.
All right. Well, perhaps I can shortcut this. So the meeting that we're talking about here, you attended that meeting on as the Chief Corporate and Investment Officer for Tanmiat, yes?
Correct.
Yes. Now, Tanmiat and TPM, who were also listed there, they were both attending that meeting on behalf of Concept Holdings Limited, weren't they? When you attended this meeting, you were attending it on behalf of Concept Holdings Limited, weren't you?
I cannot confirm that, sir. I can't recall.
Well, let's look through it then. If you go down, you'll see that the discussion on the next page, for example, you see there at 211, for example, there is discussion about the consultants. And in the fourth line, DIFC and CHL agreed to give the consultants a last chance to rectify their design, failing which they will be terminated. So this is a meeting between, on the one hand, DIFC, and on the other hand, CHL and its representatives, yes?
I cannot confirm that because but saying that the CHL was there doesn't mean that we are not representing another entity, which is Hexagon, for instance.
Well, you tell me then. You don't remember the details of this meeting. Are you telling me that you attended this meeting on behalf of Hexagon?
What I'm saying here, I can't recall exactly what was being said there, but to answer your question, if CHL is, we are only representing CHL at this meeting, I cannot confirm that at the moment, whether we're saying we are here on behalf of Hexagon and CHL, or we say only CHL.
Well, throughout this period, you were representing CHL and not Hexagon, weren't you?
No, sir. I represent both.
You represented both. So you say you had negotiations with the DIFC on behalf of Hexagon, did you?
Well, let me explain to you how I, look at the CHL and Hexagon relationship. When I came in, I was being briefed, and I understood that CHL and Hexagon owned by the same shareholders, who are the ultimate beneficial owners, and the same shareholders created CHL in Jebel Ali to represent Hexagon's interest on the project once the company, the GFC company, is being incorporated. And this is my understanding. So I wouldn't eliminate Hexagon presence in any of those meetings. I cannot say we didn't attend there as Hexagon and CHL. For us, it's just two sister company, or not sister company. I don't know what the legal term is, but it's owned by the two exact shareholders.
Yes, so they're owned by the same shareholders, that's your understanding. But you're not aware of any other legal relationship between those two companies, like a contract, for example?
My understanding, once the company is being created, Hexagon is intended to transfer all its rights in the project to that particular company. And I think that was already agreed with the DFC. Actually, in my understanding, it was.
Yes.
Yes, it was requested by DFC.
Yes, and I think you're talking about, but well, are you talking about the agreement in February 2008?
No, I'm talking about CHL itself.
Yes, there was an agreement, wasn't there, between the DIFC and CHL, and the effect.
That draft agreement, that uncompleted agreement. Yes.
Hold on. The effect of that agreement, everyone thought at the time, was to transfer Hexagon's interest to CHL, yes?
The intention was there, however, it hasn't been done. Yes.
It hasn't been done. Why do you say it hasn't been done?
Because apparently Hexagon did not sign that agreement.
Hexagon did not sign the agreement. That's the reason why the transfer didn't happen.
Not only Hexagon, other parties to that agreement also was not signatory to it.
And so the other party who wasn't a signatory to it was Nexus. Is that who you're talking about?
And the new company, the company that hasn't been incorporated yet.
Well, there was a signature on behalf of the new company, wasn't there?
Well, I wasn't there to justify that, but I'm saying the company was not incorporated at that time. The new co was not incorporated.
But your point is that if the company had been incorporated, it still would have been necessary for Hexagon and Nexus to sign the agreement before the transfer, as you describe it, could take place.
I'm saying there are 5 parties or 6 parties to the agreement, but when you go to the execution and the signature page, there's the missing signatures of some of the parties.
Yes, and so the effect of that is that if a company had been incorporated, the joint venture company, then it would still have been necessary for the missing other 2 parties, Hexagon and Nexus, to sign the agreement for the transfer to take place, wouldn't it? In your mind?
Yeah, in my mind, that agreement, if it's completely signed by all the parties, the next step to it is to create that company. Hexagon will transfer its rights and obligations under the agreement to CHL.
Right, let's just break that down. So what you said was, if the agreement is completely signed by all the parties, then the next step is to create the company. So the first thing that needs to happen is that the missing parties need to sign the agreement, yes?
No, sir, I'm not saying that. I don't know exactly why there is a new co on that agreement, in that agreement. My understanding, usually, that new co shouldn't be on that agreement, and it should be created after completion of the shareholder agreement.
Yes, but your view was that you hadn't even got to that point because the shareholders agreement hadn't been completed yet because Hexagon and Nexus hadn't signed it, yes?
Yes, so for me that agreement is not like void. It's a void, a null and void agreement. However, whatever the understanding and the commercial agreement between the DFC and Hexagon and other is still there, evident by other documents, but not necessarily by this particular document.
I see. All right. So if we go back to this meeting in February 2009, The purpose of the meeting was to discuss and hopefully agree certain aspects of the project, yes?
Sir, this is my first time to look at this document, so I would ask you to allow me time to read through it. This is my first time to look at it.
I see. All right. Well, I don't think you need to read the whole thing, but you have no recollection then at all of what this meeting was about.
Right, and that's what I stated in my statement.
All right. Well, please take the time that you need to read this. There's only really 2 pages of it.
The one was highlighted with the yellow, that I need to focus on them, or all?
Are you working from a document that's highlighted in yellow? Is the highlighting already on it?
The hard copy has highlighting of 2.0102 and 50101 and 50102.
I thought that was my highlighting, but thank you, my lord. There is another copy. If you go back 2 tabs, maybe it's better if we work from one that isn't highlighted. If you go back, I think it's 2 tabs. It's page 1435. 1 tab. It's just the tab prior. We should be looking at tab 179 now.
Okay.
So sorry, I haven't really. That's my mistake. There may still be some highlighting on this. Is there? There's a degree of it, but less. So hopefully that's better.
Just to clarify, Mr. Montague said it's not just the highlighting; these are different. They have different contents. Just I didn't want anyone to be proceeding on a misapprehension.
Is there much difference? Oh, there's a mark. Yeah, all right. Well, actually, then we are better off looking at this one because it's the first version, I think, that was produced. Presumably, this is the one that was produced by Mr. Jimar. It's Dr. Adele. Anyway, let's work from 1435. I think that's the best place to start. So please do read this and familiarise yourself with it.
Sure.
Do let me know when you finish reading it.
Okay, sir.
Yes?
No, sir. I'm still working on it.
I'm so
Sorry for
sorry.
that.
No, please.
I'm done, sir. I'm ready.
Good. All right. So having read that document, you will see that what you were talking about in this February 2009 meeting was arrangements for CHL to take forward the development of the land, yes?
That's a meeting to discuss, the status quo, what is the status of the project at that moment, and some technical issues related to that, and also the sale and purchase of the land was mentioned there.
Yes, so it's clear that everybody at that meeting thinks that it is going to be CHL, not Hexagon, who will be in charge of the arrangements for development of the land, yes?
Yes, sir. Well, for me, yes, this is what we were talking here about. CHL will be playing the role of the developer.
Yes, and CHL's role as the developer arose out of that agreement that we were discussing earlier that you say you think was void.
Yeah, before the agreement, CHL was there before the agreement, and CHL started to discuss things with DRC, and actually DRC was more discussion with CHL at that moment, and I end up with creating that document, the shareholder agreement that was not completely fine. So CHL was there, yes. It was meant to be the developer, or like I said, replacing Hexagon, and it is the right and obligation under the shareholder and the joint venture agreement as well.
Yes, but my point is that unless and until that 2008 shareholders agreement was executed properly, CHL had no rights to develop the property, did they?
Could you repeat that, sir?
Unless and until that agreement that we have been discussing was completed and fully effective, CHL had no rights to develop the property, did they?
Legally, yes, they have no. On the legal, from the legal point of view, yes, it has not officially introduced to be replacing. However, it's the common understanding between the parties that CHL will be representing, and CHL is a Jebel Ali company. It's not a Cayman Island company, and the DRC was quite comfortable dealing with CHL to continue the project.
Yes, but what's clear from this is that everybody is acting as if the 2008 agreement was effective and the transfer had taken place. That's right, isn't it?
I cannot assume that.
Well, can I ask you to look down then to page 1439?
1439?
I think it's 2 tabs forward, is it? 181? Oh, it's the same tabs. Same tab. Do you have that? Do you see there's a markup of the minutes?
Yeah, it's at 20 February 2009. Yes.
Yes, all right. And do you see the bubble comment on the right-hand side of the page? Do you see that? Do you see it, Mr. Al-Fadl?
Yeah, the writing is so small. I have to focus on them.
Just focus on the question I'm asking. I'm just asking you if you see the comment bubble. So you see that comment bubble. You've got it. You've identified it. Yes.
I can see them, but I cannot read them well unless I took my time.
All right. Yes, I'm going to ask you to do that in a moment.
Yeah, I see them, sir. To answer your question, yes, I see them.
If you look at the square brackets after the word comment, do you see it says AM1?
Yes, sir.
Do you know who AM1 was? Who marked up this draft?
I'm not sure, sir. What was AM?
Do you think it could have been Ashish Mehta?
I cannot. It can be Ashish Mehta, it can be Abdul Mahdi, it can be anybody. I cannot confirm that.
You just don't recall. All right. Ashish Mehta was the lawyer acting for CHL, wasn't he?
At that time, yes, sir.
Yeah. So it's likely that it was him who put these comments against the minutes of the meeting. No.
Well, I don't see his name there on the minutes.
Yes, but what he's done, well, quite. But can you think of anyone else who was on those minutes who would be AM1?
No, sir. This initials does not apply to any of this guys.
All right, and you'll see what the comment says. It says, from a legal perspective, Tamniat, DIFC and TPM are not parties to the shareholders agreement. Hence, I have deleted the names of all these parties. So whoever AM1 is, they've marked up the minutes to make the point that the legal relationship is between DIFC and CHL, haven't they?
Sir, I don't know who put that comment.
I see.
So I cannot comment on a document that I haven't seen.
So what I'm going to suggest is that it was very clear to everyone at the time, including yourself, that you thought the shareholders agreement from 2008 was binding and effective at that time.
No, sir, I didn't say that.
Bear with me, please. All right, so if you go to paragraph 10 of your statement, when you say, at the end of the last sentence of that, you talk about a meeting with Mr. Farouz, and you say, and I'm looking 2 lines up from the bottom, the DIFC did not give me the impression that they doubted the validity of Hexagon's rights to develop the project under the JVA. In fact, the impression that you were being given by the DIFC was that they did not doubt the right of CHL to develop the project in 2009. That's right, isn't it?
No, sir. I'm referring to the meeting with Mr. Farouz in March 2009, and you're referring to another different document.
Now, I'm not asking you about the document anymore. I'm asking you about the meeting in March 2009. You said at that meeting that the DIFC did not give you the impression that they doubted the validity of Hexagon's rights to develop the project. What I'm suggesting is that at all of these meetings, they made clear that they felt that CHL had the right to develop this project.
Sir, you're talking about CHL as like a totally different company. We always have them as the same typical, because it's owned by the same shareholder. And I think the reason of replacing Hexagon by CHL for 2 reasons, in my opinion. The first reason, this is a Cayman Island company, and it was sold to the ultimate beneficial owners, Tanmiat and Mr. Mizan and Price, without the knowledge and consent maybe of DFC. So they were not feeling comfortable with that. That's why they asked to create another company, an entity inside the UAE, and move all the rights of Hexagon to it so they can deal with it. And maybe also they have other internal issues, not feeling comfortable dealing with Hexagon at that moment. However, when I was talking to Mr. Farouz at that time, we were talking about Hexagon and CHL as almost the same entity. And just to confirm to you, Mr. Farouz was asking for things beyond that draft shareholder agreement to go on, like adding more the escrow to put like a more controlling role to DRC, and he was asking about whether this shareholder, the capital is enough. So he's going beyond what is there in the shareholder agreement. And if he just believed that was enough, he wouldn't go an extra terms that he wanted to introduce at that time.
So who did you think you were representing through the course of these discussions, Mr. El-Fadil, Hexagon or CHL?
Like I said, Hexagon had that right with the intention to transfer it into CHL. CHL was created in accordance and in agreement with DRC. So, and it will be the ultimate executor or developer of the project inside that company. So we all understand that. I'm not saying the intention of the party was not good they were trying genuinely to sign that agreement. However, the fact is not completed.
Can I ask you to look at page 1544, please, of the bundle? Should be in the same volume. Tab 197, please.
What was that?
Tab 197, please.
Yes, this is an email.
Yes, do you have that? So this refers to a meeting last week at the DIFC, yes? And you are email. So that's the first sentence, and you are emailing the DIFC to follow up, yes?
Yes.
And so you see that's dated 14th of September 2009. If you look towards the bottom of the main top section, you see about 8 lines down, it says the meeting was attended by. Do you see that? Do you see that?
Okay.
The meeting was attended by Mr. Hadith Ferouz, the legal counsel of DIFCI, and his assistant, Dr. Adel Jemma from TPM, and Abdul Sami El-Fadil from CHL.
Yes.
So it was very clear to you at the time that in all of these discussions, you were representing CHL, yes?
Yes, sir. I'm representing CHL as well as I'm representing Hexagon.
Yes, and so, so you think you were representing Hexagon as well as CHL?
For me, I'm coming from Tanmiat. So Tanmiat, was a party to the with Suleiman Al-Majid and Abdullah Al-Majid, who are main shareholder in Tanmiat, are also, and they are the part of the shareholder of CHL and Hexagon as well.
Are you being very careful to maintain this distinction between CHL and Hexagon because you don't want to make a mistake which might make a problem for Hexagon in this case?
No, sir. I'm just saying they're overlapping. For me, they are both same entity that's owned by us.
So when you say in your statement, if we just look back at that, paragraph 11, do you see your statement, paragraph 11? You should have your statement. Don't close that bundle, please. Just find your statement. You say, several months had passed since our first meeting when on the 8th of September 2009, I, together with Dr. Jemma, met again with Mr. Ferouz and his assistant. So that seems to be the meeting that you've been referring to in the email we just looked at, yes? Would you agree with that?
Yes, correct.
And you say the purpose of this meeting was for us on behalf of Hexagon to discuss the DIFC's representatives, the steps required to incorporate the JV Co. Whereas in fact, as we see from your email, you were there on behalf of CHL, weren't you?
Again, sir, I would say, for me, in my mind, Hexagon and CHL are the same. Ultimately, CHL will be the party to all execution once the joint venture company is established. And always DFC was referring to CHL to be that entity in particular. That does not eliminate the role of Hexagon here.
If we go back to the email that we were looking at, you can see that the discussions are about agreeing the details of the documents required to incorporate the joint venture company. Yes.
Yes, sir.
And so this was all about arranging a joint venture company where the shares in that company would be held jointly by the DIFC on the one hand and CHL on the other. Yes?
Yes, sir.
Yes. And then if you look down towards the bottom of this page, you see the large capital C, where it says the registered paid up capital is divided amongst the incorporators in the following manner. We're still, don't turn the page because we're still on the same page. Do you see the large capital C?
Yes, sir.
And then it's got Roman numeral 1, and about in the middle of that, it says, as documented in the shareholders agreement signed on February 19th, 2009, CHL has already paid an amount of, and carries on. Yes?
Yeah, that was documented in that agreement, and which was signed by CHL and then was signed by DFC, but not signed by the other parties.
But not signed by the other parties. So even at this time, are you saying that you thought that before any of this could be completed, you needed that the shareholders agreement needed to be signed by Hexagon and Nexus?
Yes, because unless Hexagon will be removed entirely from the picture, they need to consent by signature that they are transferring their rights as stipulated on that shareholder agreement. So
I see. So you're representing Hexagon as well, you say?
Yes, for me, I represent as Hexagon and CHL. I'm not saying CHL is not there. It's always CHL there, and we are okay with that, CHL to become the company representing Hexagon on that project company.
So if you were representing Hexagon, why could you not have simply provided or procured or obtained the signature from Hexagon that was required to make the 2008 shareholders agreement, in your view, effective?
Honestly, I joined in 2009. This agreement was attempted to be signed on 2008. So I can't really tell you what happened and why. I've seen some documents. It could be a mistake from the lawyers, could be any reason, but I cannot stipulate here because I was not present or I was not an employee of Tanmiat or Hexagon at that time.
So did you have discussions about this issue with anyone inside Tamniat?
At a later stage, we would discuss this is not completed project, not completed because of the same reason. It's not been signed by the Hexagon, Nexus, and also the new company.
I see. And those discussions that you had, that the shareholders agreement was not complete because it hasn't been signed by Hexagon and Nexus, and also because of the new company. When did you have those discussions?
Well, throughout 2009, we were discussing, the project's progress. So on a different occasion for me, but I can't recall exactly when time we were for sure confirmed this is not like a legally valid document. Maybe could be we got a legal opinion from, but I can't recall right now exactly when that had taken place.
I see. So those are discussions that are going on internally, are they, in amongst Tanmiat and the shareholders? or are you saying these are also discussions that involve the DIFC?
Okay, when I was discussing this, the progress of this matter with Mr. Fayrouz, we were always discussing about creating a company, new company, with CHL being the party to represent Hexagon there.
Yes, but you just told me that you had discussions in which it was expressly discussed that these agreements were not valid because they had not been signed by Hexagon and by Nexus. You told me you couldn't remember exactly when those discussions took place, but you thought they took place in 2009. And now my next question to you is, who were you having those discussions with?
I remember I was discussing these issues maybe with Mr. Adil Juma and Dr. Marwan Lahmadi, the CEO at that time, when he was because Dr. Marwan was appointed. We joined together same time, me and Dr. Marwan and Dr. Wan as well.
And so why did you ever discuss Hexagon executing the 2008 shareholders agreement and therefore at least solving that level of the problem?
Actually, in my mind, it's not the issue of Hexagon. Hexagon has no issue on transferring his rights to its own company. The issue was of Nexus. We don't have control on Nexus company.
I see. So you no longer think that the problem, the thing that made this contract ineffective was that Hexagon didn't sign it? Because I thought you told me earlier that you couldn't have a transfer of Hexagon's interest to CHL without Hexagon's signature. But now you say that's not a problem, do you? I'm
saying it's not a problem for them to transfer their rights to CHL. However, that never happened. So, to state the fact, this document is invalid because of the signature is not completed. Whether the Hexagon is willing or not, that doesn't change the fact it has not been executed properly. Not only Hexagon, the other party, Nexus, also is not a party yet. So the agreement, for me, is null and void.
All right. Can I ask you to look at your witness statement again, please, and go to paragraph 14?
14, yes.
Please, thank you. Now, you sent the email that we've just looked at to Mr. Fayrouz, and you say, in response, you say, however, on 15th of September 2009, Mr. Fayrouz denied that these points had been agreed. He said that he believes that we did not reach to conclusion and decisions in our meeting, and that will always be subject to our management's approvals and the business model and all finance requirements. Now, you say that you thought that things had been agreed at that meeting. Now, it's right that in meetings up to that point, both parties had made clear that everything that was being discussed was subject to management agreement, if I can put it like that. That's right, isn't it?
When we discussed it on the meeting, nothing was mentioned from our side, definitely, and also we didn't hear it from Mr. Fayrouz at that moment that he needs an extra approval from his top management. He was discussing, and I would say, no, this has to be done. The escrow has to be there, and we have to give the DFC a right. And when we was discussing with us that, our impression was that he came with an authority to do that. However, Mr. Fayrouz did not deny the content of what we discussed. He just saying, and that's what I realized, he said, yes, we agreed, but again, it's always subject to, I'm not the authority to approve this finally. I need to show it to my management, and my management has to give the final approval. So he is not denying what we discussed. He was just saying denying it was not a final approval.
Yes, but that had always been the basis of the discussions between CHL and the DIFC, hadn't it? That they were all on these issues, that they were always subject to management approval. That's my point.
See, there's a different meeting happen with different people from DFC. At certain point, we have people with the managing director, like Mr. Bishr Brazi, or sometimes with Mr. Omar bin Suleiman, the governor, His Excellency himself, or other people with the authority. They were at certain meetings, and they can take decision at that moment. So not necessarily all the meetings will always go to a higher approval. You can get approval at the moment if that person feels he has the authority to say so.
All right. Now, bear with me, sorry. Now, if we go back to that email that we're looking at, do you see paragraph 3 of it?
Yes.
So it's on page 1545 now. And do you see it says, we agreed during the said meeting that CHL will present in the next 6 weeks a new detailed financial model for the project based on the latest project design. Yes, you see that? I just want to ask. Now, this email was sent on the 14th of September 2009, yes?
Right.
And you know that the project consultant, Perkins and Will, had been terminated in June 2009, don't you?
I know that it's been terminated, but I cannot recall exactly what the date for that termination.
But they've been terminated before you sent this email, yes?
Yes, but at that time also we were talking with CSI, and they were presenting another design at that time. So we have somebody working on a design at that time.
Well, firstly, nobody was actually appointed in place of Perkins and Will, were they, to prepare a new design?
I recall in our presentation to them, we showed that the design was being given to us by CSI, and I recall CSI was given the issue that they want to take the project on a design and build basis.
Well, I'll come back to CSI, but CSI were never appointed to prepare a concept design for the project, were they?
There was a discussion with them, and we have a presentation we submitted, but yeah, I don't recall legally there was a letter of appointment, because when they submitted the proposal, the concept design, the initial one, we have submitted to the DIFC, and they have never came back with the final decision on it.
Well, there was no fully formed even pre-concept design prepared by CSI, was there?
There was, and it was there in my presentation to them.
Well, we see in your presentation, and we'll come on to it, a single picture of a tower, which is a concept in a sense, but it's not a formal concept design, is it?
Well, I'm not a technical guy. I cannot comment on all these technical issues. This is issues we already have TPM taking care of it, and TPM was leading communication with DFA in that regard. So I cannot exactly say whether there's any design that makes sense has been submitted or not. I'm not the person to comment on that.
As we've seen, paragraph 3 here also refers to a detailed financial model.
Yes.
Now, as I understand it, CHL approached JLL for some sort of financial model around this time. Is that right?
JLL Latang, yes, we were asked them to give us like a cash flow study, feasibility study and market study. So it will be reflecting on a financial model for the project. Yes.
Yes, and JLL, I think, produced a financial model. We'll come on to it later, but in about December 2009. Do you remember that?
I remember they submit, but I can't remember exactly the date. I have to look at some dates on that.
Yes, bear with me. I'm just going to try and find a financial model. We'll come on to it later, but in about December 2009. Do you remember that?
I remember they submit, but I can't remember exactly the date. I have to look at some dates on that.
Yes, bear with me. I'm just going to try and find it for you. Sorry. Yeah, so if you go to page 1577, it's tab 201.
Yes, sir.
It's corrected.
Yes, sir.
Is that the financial model that was being prepared?
Yes, sir.
I see. And so that's the one which was promised within 6 weeks of the September email that we've just been looking at.
Yeah, but I don't know if this is the final or just like an internal draft of the study, of the feasibility study. The production of this one, I cannot tell if this is the final one or just one of the early drafts. I can't.
Well, it helpfully calls itself a draft final report. So a bit of both, I think, is probably the answer to that. But I don't think it matters.
Yeah, in fact, yes, you're right. It says draft final report. Yes, I can see that.
All right. So is it fair to say then that between the email in September and at least December, the DIFC was waiting for you to produce this financial model that was being prepared?
No, sir. When I sent that email, I got a reply from Mr. Harvey say, before you go any further, I need to confirm the points in the meeting with my management and I will come back to you. So they were not waiting for us. We were waiting for them to reply, and they didn't reply, and I have to chase them literally with phone calls.
But you went ahead and instructed JLL anyway, right?
Yeah, we were paying for that, so we incurred that cost. So even the DFC did not approve it. It's part of our attempt to make the project progressing.
But you didn't wait for Mr. Ferouz's response to your email before you went off to JLL, though, did you?
In fact, I can't remember. Maybe at that time we already engaged with JLL to prepare this study for us. And whether the DFC accepted or not, we were okay with it, and we were ready to incur that kind of cost if for any reason DFC has objected to it.
All right. In paragraph 20 of your witness statement, can I ask you to look at that, please?
Yes, sir.
You refer to some exchanges in early 2010, and you say, do you want to just I'll let you read that.
Yes, sir. Yes, sir, I read it.
All right, so you say that Mr. Ferouz was saying that there was confusion about the role of Tamiat in the discussions, and you say you thought that was a bit odd because you had communicated on behalf of, and then you say Hexagon / CHL. Now, CHL, as we've discussed, was the party who would have had an interest in the process if the February 2008 agreement was effective. Hexagon was the party who would have had an interest if it was not effective. But as we've seen throughout the documents, at least that we've been looking at, you had been communicating and saying that you were attending on behalf of CHL, whatever was in your mind. So don't you think that the confusion was perhaps a little bit unsurprising when suddenly Hexagon re-emerges with the appearance of King and Spalding in early 2010?
The response I got from Mr. Fayrouz at that time, he was not objecting to us mentioning that we represent Hexagon and CHL. He was just saying what Tenmiat will do and what King and Spalding will do and who is at that time. But he was not referring to, and he did not mention at all whether verbally or in writing he is objecting or he has a problem with us representing Hexagon / CHL. I don't see it anywhere.
All right. Well, when King and Spalding come on board, they start communicating. Presumably you were participating in giving them instructions, were you?
Yes, sir.
Yes, all right. And what King and Spalding ask for is that they say Hexagon wants to discuss a new arrangement which is different from the 2008 shareholders agreement. That's what they wanted, isn't it?
No, sir. That was not the thing. When we got the answer from DFC for the meeting, they would say, tell us who are and give us the documents to prove the entity of Hexagon. And what King and Spalding would tell them, yes, we will show you that, but we want to discuss as well the whole project.
Yes.
The whole project in that context. But and we will explain to you who are the entities behind Hexagon and all this. But as well, our meeting is not just for that reason. We wanted to discuss the matter as well, because if you recall, I said from September 2009, I sent the email, and he was telling me, okay, I will get back to you after I get my approval. Since then, he never sent me any response to that issue. So our intention from involving King and Spalding with us is also to look into the legal point of it, and maybe the DFA will take us more serious. Now, it's not just a layman talking to them, but also we have a legal firm that can be there to advise us on our legal obligation and rights.
But in terms of what you wanted them to do, you wanted them to come on board, to approach the DIFC, to discuss the whole project in the sense of amending the existing arrangements.
No, sir, we just have them there to help us. If you can look at my email, we were saying King and Spalding will take care of all the legal issues, follow-up, but we're still going to be there looking at the commercial and non-legal issues.
But what I'm trying to do is understand what you mean by looking at all of these things. What you mean by looking at all of these things is change.
Okay, we haven't.
So what you meant by looking at these arrangements was that you wanted them to be changed, didn't you?
No, sir, I didn't say that. What I'm saying, we have a situation where we, in the middle of a discussion, a preparation to create a new company, everything has stopped. And we were not getting a firm answer from DFC. And they said, okay, we'll get back to you. And I think at that time, there was a change on the management of the company. management on DFC and a new management there. They wanted to understand what is going on, what is the background of this, and that's why maybe Mr. Fayrouz was acting that way. Is strangely, because he was been dealing with me for a whole year, and we were discussing details of how we get the company set up, and then all of a sudden he asked me, I want to know who is who. So could be like a higher management there he wants for that purpose. So when we have King Spalding with us, is to discuss along with us to move that situation and see, look, we are here, we wanted to take it to the step where it can be executable, that project. That's what we meant.
So you wanted to approach the DIFC to reach an agreement to do something different than the agreement that was in the 2008 shareholders agreement, didn't you?
No, sir. We still okay with the commercial terms that's been agreed prior to 2008 draft agreement. And by that I mean the increase of share of DFC from 15 and 17% to 32%. The increase of the build-up area and all that technical issues and commercial issues, and also the ability of us to finance the project in a different way, whether with extra equity or like construction finance, or even the ability to borrow money. All those were discussed and agreed in different meetings. However, we failed to put them in writing on that legal document because it has not been signed. And to go forward, we're still talking about the same project. It's the same Hexagon project, which is the same land, P01, the same shareholder, the same project, which is a real estate mixed-use development, iconic tower. So we were not talking about a different project. We're talking about the same project.
Can I ask you to look at page F1713, please? It might be in volume 4. Tab 208. Thank you.
F1711?
F1711, but then if you go forward 2 pages to 1713.
Yes, sir.
Do you see there an email from Mr. Jawad Ali, dated 26th of January 2010, yes? And Mr. Ali is sending this email on your instructions, yes? Yes?
Can I read it, sir?
No, well, all right, yes, go on. Familiarize yourself with it, go on.
Yes, sir. Yes, sir. What is the question now?
So you said, and the bit I want you to look at is the 4th line down at the end of it. It says the investors would like to discuss the structure of the investment in general, the capitalization of the new co, the transfer of the property, and other related matters regarding the joint venture and the development of the project. Now, what I'm going to suggest is that when it says the investors would like to discuss these things, what it means is the investors would like to negotiate about those things. Yes, is that right?
No, to me, discussing is not necessarily means negotiating.
Of course, it doesn't necessarily mean negotiating, but you were giving the instructions at the time, so I'm asking you what was meant by this at the time. And so I'm not asking you what it necessarily means, I'm asking you what it means. What it means is that you, on behalf of the investors, were instructing Mr. Ali and his firm to renegotiate these issues, weren't you?
No, sir, that's not true. What it means to me here, we are still discussing the structure of the project, looking at it from the same point within the umbrella. For me, sir, the joint venture agreement is still a broader framework. It's a framework agreement that needs to be broken down and stipulated in additional documents, which is like the sale and purchase agreement, the new company article of association, all this. So within that, we have to put how the project is going to be structured. We will discuss all that because if you look at why we are doing that, we are replying to the DFC request of the meeting. They wanted to know who the entities. And what we basically saying to them is not just that. We want to discuss beyond just showing you who are the entity. We want to discuss the project from the point it stands and how we look at it going forward. That's simply what we are meant by that email. I didn't hear you, sir.
It's my fault. There was a bit of background noise here, so I muted myself so we could hear you. If you go back to the beginning of this tab, it should be 1711.
Yes, sir.
Do you see there an email from Miss Kira Summers to you, dated 28th January 2010? And it says, thank you for your explanation on the attendance of the meeting and also clarifying the role of King Spalding. But it says, I'm still not clear on the role of Tamniat and so forth. And the ambiguity is the legal capacity of Tamniat. But then it says, it is stated in my email that the agenda of this meeting is to complete the required legal documentation in relation to this project. Therefore, there will be no room for any commercial or business discussions. Once we finalize this, it'll be very clear for both parties to engage in the commercial issues. So the DIFC comes back and says there's no room for commercial discussions. The purpose of the meeting is to finalize the legal documentation. Yes? And then the final piece of this, I'm afraid we have to go forward to page 1722 to get the response.
Tab 211.
Tab 211.
Okay.
Do you have tab 211?
Yes, sir, I do have.
And I think you can see that it's a response to the email that I just showed you. And the answer is sent back by Mr. Ali. And he says, thank you for your email, Hadith. You are right that the meeting should focus on the structure of the investment and legal documentation. However, there are a number of business and commercial issues which will affect the structure, documentation and process of completing the same. So, at this point in time, the DIFC is proposing the finalization of the documents that are necessary, but actually Hexagon did not want that, did they? They wanted to renegotiate the transaction at this point. That's the position, isn't it?
No, sir, not at all. I disagree with you on this particular thing. The request from DIFC, which was sent to us, is to show the documents, legal document of Hexagon and CHL and all the documents related to that. And they said, hold on, before we go further to discuss commit. And I will take you back to my initial email on 2009, September to Mr. Hafiz, where we discussed the construction and everything, and he said, "Wait, I will get approval from my higher management, and that's it. Then we went to that standstill. We were trying to call them to get them. The first time they communicate to us, it said, before we discuss about the commercial matters and the company capital and distribution and that, we need to know who's who and the entity. So they're doing their own due diligence on us before continuing discussing the project in the commercial point of view. So what we're saying to them, we wanted to combine both purposes. We will show you who the company is, but we want to discuss the project. That's what we're saying to them. So it's not like they want to proceed with the joint venture, because they were not talking about they are ready to do the joint venture at that time. They want the legal document of us. So basically, it's like a compliance. We look at it here, it's not like a business, like an arm's length. You see the problem always with DFC, they have confused roles. They are more into like compliance, regulator, government entity, not just a private sector partner to you discussing things. So they said, okay, before we talk about any business matters, tell us who are you guys. And again, we say, okay, we'll show you that, but we still want to discuss the business matter. That's basically it. They're not saying about we are ready to do the joint venture incorporation, and we say no. That's not, I interpreted from those correspondence there.
My lord, I think we are due a break now for the stenographer. Is now a convenient moment for 10 minutes? You're on mute, I'm afraid, my lord.
Yes, we'll take a 10-minute break now for the transcribers, Mr. Al-Fadil.
Sure.
During the break, the rules are that you're not allowed to talk to anybody about the case or about your evidence. You can talk about other things, but no, not then. All right?
Sure, sir. Sure.
Thank you very much. 10 minutes, please.
Thank you. With your permission, my lord, I'll carry on.
Yes, please.
Mr. Al-Fadil, if you could pick up your statement, please, and just turn to paragraph 22. Should be getting some help with with the documents behind the scenes, but I appreciate it's tricky to keep track of all these bundles. Let's look at your statement, though. Paragraph 22, you refer to a memorandum dated 21st of March 2010 that was prepared by King and Spalding. And I think you say that you had a role in preparing that memorandum, yes?
Yes.
Yes. All right. And you call it the first memorandum. And paragraph 23, you say the first memorandum was intended to do various things. And paragraph 2, explain why the proposed legal structure, which mirrored the structure set out in the JVA as amended, was better than the structure proposed in what you call the draft shareholders agreement. So the first thing is, you would accept, wouldn't you, that the structure in the shareholders agreement was different from the one in the joint venture agreement, yes?
The legal structure, yes, because of the introduction of a new entity, which is CHL, and also the JV company, the new company to be incorporated. So yes, I would agree with you. The legal is different.
Yes, all right. If you agree, it's fine just to say yes. That's fine. We'll move faster. The structure being proposed in your memorandum was therefore different from the structure being proposed in what you've referred to as the draft shareholders agreement, yes?
Yes.
So is it therefore fair to say that at this point, the shareholders of Hexagon and CHL did not want to proceed with the 2008 agreement?
We want to rectify them.
You didn't want to proceed with the structure and therefore the whole of the 2008 shareholders agreement, yes?
We were saying this is not a binding document. We cannot proceed with a non-binding document, with a null and void document.
And it wasn't binding because it hadn't been signed by Hexagon and Nexus. Yes?
Yes.
So you wanted to amend the agreement, did you?
Under the umbrella of the original joint venture agreement as amended in 2004, yes.
Yes, but you wanted to amend the 2008 agreement, yes?
Recreate.
Recreate, all right. And in fact, the memorandum sought to create a mixture of some elements from the original joint venture agreement, some elements from the 2008 agreement, didn't it?
Can we look at that memorandum to refresh my mind?
First, let's see if you agree with my characterization of what you were proposing, and then we'll go on to look at the details. Would you agree? Would you agree that what you were proposing at this stage was in effect a mixture of elements from the original joint venture agreement and also some elements from the 2008 agreement and also some elements that were in neither agreement?
No, okay, I don't agree with you. I'm saying the original document that we have to refer to it is always will be the joint venture agreement as amended in 2004. So we have to put it in the right structure of it. Whether those part of those things are the same one typical on the draft shareholder agreement of 2008, that's okay. We still have to use them within the correct document to be implemented under the umbrella of the joint venture agreement as amended in 2004.
All right. Can you turn? Let's have a look at this document, shall we? Have you got bundle J?
Bundle J.
It's tab 4.
Okay. Document number?
Number 4.
Okay.
And it starts on page 61 if you have it.
Yes. 61.
Yes, 61. And do you see there that under A is a historic timeline? Yes?
Correct.
And do you see there the date 19th of February 2008?
Yes.
And what it says is a shareholders agreement is entered into with respect to the formation of the project company to own the project between Concept Holdings Limited, DIFC Investments, the successor to DIFCA, and the yet to be formed project company. So as at the date that this memorandum was prepared, your understanding was that the 2008 shareholders agreement had been entered into, wasn't it?
My understanding is the word enter into is that it's like they started to execute it. However, it's not 100% fully executed.
So when you enter into an agreement, are you saying that that doesn't necessarily mean that you're bound by it? Is that what you're saying?
No, I'm saying all the parties mentioned there have not exactly signed confirming that they are agreeing to the contents of that agreement. So part of the shareholder on parties to that agreement, yes, they signed, but I cannot speak about those who did not sign. So therefore, I can't say I have a legal document in my hand. But yeah, their intention is to enter into that agreement, meaning completed, executed, and become a valid document. But since it's not completely signed, it remains, you can call it a draft share agreement, and just any other document, but not a legal document.
But nowhere in this document does King & Spalding say that the 2008 agreement is not binding, that it's not contained in that document.
I need to read the entire document to reply to you.
Have you not read this document recently? You can't remember what's in it?
I cannot remember at this moment.
All right. So you don't accept what I say?
No, sir. I say give me the chance to read it to answer you, sir.
Read the whole document, do you?
Do you want me to read the whole thing to answer?
No, I don't want you to read the whole thing. You're suggesting that you need to read the whole thing to answer my question. I'm asking you to confirm. You told me earlier in your evidence that in the memorandum you were saying that the 2008 agreement was not a binding document. That was your evidence that you gave earlier. I'm suggesting to you that there is nowhere in this document does it say what you said. So now you're
to
saying
answer you, sir, I need to read the document before answering you.
Well, how were you then able to give evidence earlier stating that this document said that the 2008 shareholders agreement was not binding?
So you are asking me about a particular email was sent, and
No, I asked you about this memorandum, Mr. El Fadil. And you said, we are saying in this memorandum that the 2008 shareholders agreement is not binding. You now say you don't know what's in the memorandum. So I'm asking you how you were able to give that earlier evidence, Mr. El Fadil.
because the whole objective, if you read this document, its whole thing is trying to rectify what was not right on that document. So apparently, we are saying this is agreement, this attempt to correct what was not right. Whether we said it explicitly or not, before answering you, I ask you your permission for me to read it, so I answer you. And you
Mr.
don't want me to read it now.
Well, I'll show you some other bits of it, but before I do that, Mr. El Fadil, you'll recall there was another memorandum in 2012, yes? Do you remember that?
Yes, there's another one on the screen.
And if we look at the corresponding section of that, it's at tab 25 of the same bundle that you have.
25, yes, the last one.
Yes. And on page 199, which is the second page of the document,
Yes, sir.
you see in the middle of the page now, under the heading 19 February 2008, do you see that?
Yes.
You say that it says there similar words, a shareholders agreement is entered into and so forth. And then if you look on the fourth line down, starting at the end, some further words have been added. The shareholders agreement purported to terminate the amended JV agreement. However, neither NextCap nor Hexagon executed the shareholders agreement. So is it the case that between 2010, when the first memorandum was prepared, and 2012, when the second memorandum was prepared, that on your side, you and the shareholders had taken the view or instructed King and Spalding to make the argument that the shareholders agreement was not binding?
Actually, from the day one, from the 2010, that was same. We maintained the same view. However, if Mr. Jawad did not contemplate that same thing expressly on his 2010 memorandum, so that doesn't mean we maintain the same view. Our view was continuously the same.
Can you turn back to the document we were looking at before, please? So we're back into tab 4, page J62.
52. I'm sorry, sir, I can't follow you. Which document?
J62, please.
J62.
Tab 4.
J62, yes, correct.
Yes, and I'm looking underneath the proposed legal structure, down towards the bottom, the second to last paragraph there. It says both the amended joint venture agreement and the shareholders agreement both contemplated the formation of the project company. This has not yet happened. We would suggest that the shareholders agreement needs significant revision in order to reflect the correct structure for the project, and to that end it would be preferable to prepare a new shareholders agreement incorporating elements of the shareholders agreement and the requirements stipulated for any such agreement as set out in the amended JV agreement. So the proposal was that there would be a new agreement altogether, taking bits of one and bits of the other, yes?
The proposal was, to sign a new shareholder agreement in line with what stipulated in the JV agreement as amended in 2004.
All right. And then it goes on to outline the agreement that's being proposed.
Which paragraph are you referring to, sir?
The next paragraph says the starting point for a new shareholders agreement would be that the DIFC contributes land on which the project will be developed to the project company, and that Hexagon contributes to the agreed working capital requirements of the project company. So up to now, it's saying Hexagon contributes working capital, yes, and it makes a distinction between working capital and the rest of the cost of the project, doesn't it?
Yeah, there is a difference between the total capital, the total project capital, and the total project cost. Project cost will go beyond the capital. Can include, I will just give you an example, like construction cost,
Yes.
construction finance, or the pre-sale, the plan sale. All this can contribute and be covered the gap
Yes.
between the capital, the total project capital, and the total project cost.
And in relation to the total project costs, we see that the proposal is this. Hexagon will also be responsible for contributing the equity portion of the total cost of the project. Do you see? And then in brackets, and procuring financing on behalf of the project company. Hexagon may contribute such equity portion by way of additional equity into the project company, shareholder loans, or a combination of both as Hexagon deemed appropriate. So the memorandum proposed that the joint venture company could borrow the project cost, yes?
No, we say we will borrow on behalf of the company, but we are not gonna. We didn't say here particularly that the company is will be taking any risk on that or giving any like collateral. We still can generate the additional funding required by, let's say, mortgage another land that belongs to us or any other term. But we say on behalf of the company, but not necessarily the company will give any kind of extra collateral. However, this was already agreed with Mr. Bishir Braz before in terms of increasing the DFC share from 15 and 13% to 32%. But in this particular memorandum, we were just saying this is our duty. We will take care of that.
Well, what it says is it says procuring financing on behalf of the project company. So what that could only mean is arranging a loan to be taken out by the project company, isn't it? That's what that means, isn't it?
It can be unsecured loans. If you are aware of the financing, and I'm sure you are, there is a secure loan and unsecured loan. We still can get a loan that's not necessarily secured by the project company. It can be secured by other means.
I didn't bring up the question of security. I'm dealing only with the question of who is doing the borrowing here. This is borrowing by the joint venture company, yes?
To me, it says Hexagon will borrow on behalf of the company.
No, it says it will procure financing on behalf of the company. It doesn't say Hexagon will borrow. It says procure financing. So it's
it
the
doesn't
joint
say
venture.
also the new co will borrow as well, sir.
But that's what that means, isn't it?
No, not. I cannot assume that.
So your position is that this is a proposal which does not indicate that the company will borrow anything.
I can't see anything on this document that would give that impression. You know, what we're saying here, we will be taking care of whatever necessary to get this project complete. and it's our duty as a developer.
So who did you contemplate would be the borrower of shareholder loans then?
Excuse me, sir? Say it again, please.
Who did you think would be the borrower of shareholder loans in this scenario?
Yeah, again, the company can be the borrower, but we didn't ask them to. Shareholder loan doesn't need any security there, so it won't incur any additional burden on the company.
Yeah, so when you said earlier to me, there's nothing in this document that gives the impression that the company could borrow, reference to shareholder loans gives the impression that the company could borrow, doesn't it?
What I say here, the developer, Hexagon, will take the action needed from it to make sure that completion of the money is coming somehow or another. But we did not particularly here saying this will be like an extra burden on the project company. And again, I was referring to the already agreed that the company will be given the right to borrow, and this was confirmed by the managing director of DFC back then. I remember 2008 or 2007 that the company will be allowed to borrow money. So I don't see that something is a new to introduce. However, in this particular document, we didn't go to that details. We're just saying we will procure whatever necessary funding required for the company.
Right, but you know that the JVA did not permit the company to borrow, yes?
The original joint venture agreement did not give that right to the company, correct? But there is discussion and agreement and proposals between the two parties because the original document was talking about 15%, the share of DFC. Later on, they were talking about 35% or 34%.
So you... Sorry, carry on.
So I'm just saying, within the development of the project, there is some commercial terms that's mutually agreed or will be discussed or agreed between them as necessitated by the situation.
So you think that there was a discussion in which the terms of the original JVA were amended to permit borrowing by the joint venture company? That's your view, is it?
Okay. The original joint venture agreement said that all the money has to come from the investor in a cash liquid. I've seen agreements between the two parties and actually from DFC in writing saying, yes, we can allow you to borrow in return for we get more shares. And I've seen that.
But I thought you told me earlier that you didn't think that the JVA could be amended without the agreement of Nexus.
We are still at the level of discussion. So, what I'm saying, I didn't say the JVA. I was saying the shareholder agreement.
You said the shareholder agreement was in effect. Unbelievable.
I believe that will be
Excuse me, I'm
just
gonna
the audio.
call back. Right, just give me a minute.
Mr. Al Fadel, can you hear us? I know, he's talking through his phone, I think.
Hello?
Mr. El Fadel, we can hear you now. Can you speak, and we'll see if I can hear you.
Okay, sorry, sir. Sorry for the interruption. We got disconnected.
No, that's fine. We were talking about the difference between Hexagon investing the total project capital and the joint venture company being able to borrow the total project capital. And you would accept that a switch like that would be a hugely significant commercial change to the transaction.
Sir, absolutely. Like I'm saying, again, I would confirm this. For me, always the joint venture will remain a framework agreement. It's a broader agreement that needs to be broken down into many execution agreements, such as the shareholder agreement, the JV company, article of association, sale and purchase for the land, and all the et cetera documents. So always I can look at it like our constitution was given the guidelines, but there's nothing wrong with two parties. The two parties mutually agreed whatever field that is more beneficial for both of them, for the interest of the project, to amend some of the terms there, and still will be a valid joint venture agreement for the same project.
That wasn't the question. The question was if they were to agree to make an amendment to permit Hexagon to contribute by arranging loans by the company, Hexagon having previously been required to invest, if there was that change, that would be a hugely significant commercial amendment to the transaction, wouldn't it?
Sir, again, I would repeat what I said. I wouldn't say this is I hear you, sir.
I'm just asking you to answer the question. All right, well, I'll move on from that. The memorandum also does not propose any specific upfront cash investment by CHL, does it?
No, it says in the first and second line on the second page, J63, it says Hexagon will also be responsible for contributing the equity portion of the total cost of the project. So it's saying that they will inject that money.
Yes, but it says that it can do that. Hexagon can do that by arranging loans, doesn't it, for the company, and therefore Hexagon would not be required to make a cash payment as it had been required to do under the 2008 shareholders agreement. That's a different proposal from the 2008 shareholders agreement in that regard, isn't it?
No, it says we will do that and we will also procure the financing on behalf. So it says we're going to do both.
No, but it says in the next sentence, Hexagon may contribute such equity portion by way of, and then lists various possibilities, including shareholder loans, as Hexagon deems appropriate. So it is up to Hexagon how it contributes the project costs. It can do so however it likes, including by obtaining by obtaining borrowing on behalf of the joint venture company, by getting the joint venture company to borrow. So this is a change, isn't it, from the requirement under the 2008 shareholders agreement, which required $98.5 million to be paid in exchange for Hexagon's shares. Sorry, for Concept shares.
Again, sir, you're referring to the shareholder agreement that's not executed, which it says 98 million.
Yes.
Okay. What we're saying here, I don't see anything on this memorandum that suggesting that we will not pay any equity. We were saying we will pay the equity plus whatever required to complete the project by other ways and means.
What about this time you were suggesting, weren't you, that Hexagon might contribute something in the region of 200 million dirham? Do you remember that?
As a startup. You don't need the whole project money up front. That's not making sense in a commercial way. The project would take time. So we're saying as a gesture, we are ready right now immediately to inject 200 million dirham, which is about $60 million right away.
Isn't the reality that you told King and Spalding that what you wanted to do was reduce the cash investment required to get this project moving forwards? That was a key priority in the instructions that you gave them, wasn't it?
No, sir. We didn't say that.
And what you instructed them to do was to try to find a way either to amend or get out of the commitments that there were in the 2008 shareholders agreement.
What we give them instruction is to get this project executed in a way acceptable and agreeable to both parties.
And then in paragraph at the bottom of the same page, do you see it, J63? You suggest Hexagon suggests some next steps. And the first step is to finalize a new shareholders agreement among the parties within 30 days. And then the second step is to incorporate the project company at the DIFC within 30 days of executing the new shareholders agreement. So what you were proposing in this memorandum was that the the joint venture company would not be incorporated until after a new shareholders agreement was agreed. That's right, isn't it?
No, what we're saying here, those are all the pending issues that we have to take care of them, not necessarily one by one, but to make like a common sense, to incorporate the company, we need to agree or specify how much the capital and all that. And those will be written on the shareholder agreement. So that's, common sense. You need something in detail, then you do. But we say all this is we just put a time frame as a reference. Within that time we would have it, but also by that time the company would be incorporated, because the incorporation of the company will be in DFC itself. So
yes,
when we go to DFC regulator and we say we want to incorporate this company, they will ask us, well, how much the capital, how much the share of each one, and all those things. And they will ask us, do you have a memorandum of association or a shareholder agreement? Obviously, we have to come up with one to complete the incorporation of the company.
And you'll recall we looked at some documents from the end of 2009, which were documents you were discussing for the incorporation of a company, a joint venture company at that stage, yes?
Yes.
You remember
we
those
were
documents?
discussing how to incorporate the company. Among the things we were discussing, the distribution of the shareholder, the paid-up capital, the escrow account.
Mr. El Fadil, if you just listen for and wait for the question, and just listen to the question and answer the question. So I was just asking you, I was just reminding you of those documents. Those documents that we looked at were prepared for the purpose of incorporating a joint venture company, which would be part owned by CHL, yes?
Could you repeat the question, please?
Those documents that we were looking at from the end of 2009 were prepared for the incorporation of a company which was to be part owned by CHL, yes?
Are you referring to the meeting with Mr. Hafiz on 2009?
The documents that we looked at, yes.
I don't recall we looked at documents. What documents exactly?
The emails that you proposed, where you proposed changes to the Articles of Association, in that email, you are proposing amendments which are intended to incorporate a company that is to be owned by CHL, yes?
I was just listing down what has been discussed on the meeting. I was minuting the meeting, and I was asking Mr. Fayrouz to confirm that.
Yes, and the discussions were about incorporating a company which was to be owned by CHL, yes?
By both, by DFC and CHL, both together,
yes,
to be the project company.
Yes, and so by the time we get to 2010, yes, when you are proposing the incorporation of a joint venture company, you are not proposing the incorporation of a company on the same terms as you'd been discussing at the end of 2009, were you?
No, it's the same company we were referring to.
But if you'd incorporated that company, it would have been owned 65% by CHL.
Again, the percentage is the same here, if you look at it.
But here you're proposing a company which is going to be owned by Hexagon, yes?
Sir, when we were discussing on 2009, we were discussing CHL as the company to be replacing Hexagon. Here, we came back and say, okay, the proper way is to keep Hexagon on.
All right. Now, go back to your witness statement, please, and let's look at paragraph 34.
34?
Yes. And you refer to a meeting of the 15th of February 2012.
Yes.
And you refer to a meeting,
that Suleiman Majid supposed to meet with deputy CEO of the IFC. Yes.
All right, thank you. And then if you keep that open and we go to page in the bundle, page 1760.
1760.
215, is it? Tab 215.
The one in J. Which file is that? I'm getting too much letters here. Which one?
It should be volume 4, F4.
F4. Can you have it on the screen so we can follow you? Because we have.
Do you have case lines up? We'd understood that you did not have access to case lines. If you have case lines, this could have been done much faster, but we'd been told you didn't have it.
No, we have.
Yeah, we do.
I believe it was in the email to the registry, Mr. Montague-Smith, that both were available.
I see, thank you. So what needs to happen? You need to click on present.
He needs to click on present.
So do you have the bundle open in front of you? Or do you have case lines open in front of you?
We have the hard copy and the screen.
Yeah, so at the top,
Tab,
there should be a tab which is present. You need to click on the tab present.
Present. Yes, sir.
Have you done that?
Yes.
And then you need to click follow presenter.
Follow the presenter. Yes.
And you should see
Sophia?
Miss Sophia, yes, and if you click on her,
Okay.
then she ought to be able to bring up documents for you. And that may speed things up. Thank you very much. All right. So this is a, what's that? So this is a presentation which was prepared. Was this prepared for the meeting that you've been referring to in your witness statement? You see, we just referred paragraph 34. You refer to a meeting 15th February 2012. And then you'll see at paragraph 34, there's a footnote, and the footnote is to footnote 20, which takes you then to, I think it's this document, isn't it? 56, yeah, it's 56. 56 is an email chain which attaches this document.
Okay,
So,
the email from Sulaiman and Majid to this lady, yes.
Yeah.
But I'm saying here, I did not attend that meeting.
Oh, you didn't, I see, all right. Were you involved in the preparation of this presentation at all?
Yes, sir, I was.
You were. Okay, and if we go forward to page 1778.
1778.
I believe it can be rotated for you.
Okay.
So that's 1779, is fair.
Okay. Yes, sir. We have half of the page on the last point.
We're struggling, I'm afraid.
Okay, I got it on a hard copy as well.
If you're working from it from hard copy, perhaps let's start on 1777. And do you see there the proposed structure? And then on the next page is 70. So you'll see the proposal at this stage is a 65-35 split in ownership, but this time between Hexagon and the DIFC investments. Yes.
Yes.
All right. And then on the next page, you see 1778. You see sign a new agreement between Hexagon and DIFC as step one in the way forward, and then create a new company, project company, to be owned by Hexagon at 65% and 35%. And then it says
DRC to transfer. Yeah.
Where's the reference? Michael, are you following on this next? Because I've lost the reference. Bear with me, I'm sorry, my reference has gone wrong. Where's the reference to that? I'm so sorry. We've. This is my fault entirely. We've got a reference missing. Yeah, I know we need to find them. Sorry, if you just pause, it's my fault. I'm afraid we've lost a reference. There's a number of different copies of this presentation, and I believe we've just got the reference to the wrong one. Yeah.
This is February, so we are right chronologically.
Yes, I think the point is simply that my notes have gone slightly wrong at this stage. Okay. J. Oh, I see. Yeah, so we need to. Yeah, I see. J83 is it? Yeah. So sorry. The document we're supposed to be looking at is in J83. J83?
It's not in the February presentation, it's in the April or an earlier one.
I see. Yes, thank you. All right, it's an April presentation, yes. It's a different presentation I wanted to take you to, in fact, and it's behind tab J5. So sorry. So this is a version of the presentation that appears to have been created on the 30th of April 2012. Do you have a copy of that?
No, sir.
It's bundle J, tab 5, 83.
Okay, J5 is, oh yeah, it's attached to an email, right?
Yeah. And do you see this is, did you have a hand in preparing this presentation as well?
I believe so, yes, sir.
All right, and if you could turn forward to page J83, please. J83.
83?
It should be up on the screen now, although I'm afraid we're one page after. Sophia, is it possible just to scroll up the page?
Yes, I got it, sir.
Oh, great. So, all right, thank you very much. And do you see there? It gives the shareholding split, the proposed split, 65-35, and then there's a note at the bottom. It says the proposed shareholding split was based on the valuation of the land in 2008, and the project cost is based on the older design, and may need to be adjusted. So, was it your understanding at the time that the shareholding split was to be determined by the comparison of the amount contributed by Hexagon, funding the project fund, the project cost, and the value of the land contributed by the DIFC?
My understanding that initially when DFC agreed to give the plot of the land, they fixed the price at based on the valuation of the land at that time. And on 2008, they have asked for increase their shares based on that, as well as the build-up area was also increased. So that's my understanding how the combination was being done.
Yes, but at this point in April, is it 2012? Your understanding was the shareholdings of the company needed to be determined by reference to the actual updated valuation of the land, yes?
Yeah, we were saying that to be fair to DFC as well. That's for the benefit of DFC.
Yes, but it says that it may need to be adjusted. So you knew that the effect of the agreement, or your understanding of the effect of the agreement, the original joint venture agreement, was that the valuation of the land would always need to be updated, yes?
Yeah, my understanding, we never had an issue with the shareholding to be reflecting the fair contribution, whether it's land or the actual project cost.
All right. Can I ask you to go back to your witness statement, paragraph 36?
36?
36. So yeah, it's the next page from the one that we were looking at. Do you see? Oh. You see there you say, on or around 17th of March 2012, I received a telephone call from Mr. Nabil Mohammed Ramadan and so forth. And then you say, Mr. Ramadan requested that we send the DIFC an official letter explaining the history and background of the project and Hexagon's relationship with the DIFC, copies of any agreements signed with the DIFC, and a new business plan setting out the shareholders' intentions to take the project forward. And then you say, I shared this business plan with the DIFC at the time, you give a reference. Do you see the reference there is footnote 24? And then footnote 24 is a presentation entitled Brief Business Plan for Discussions prepared by Tamniat, and that is F7. So you think, and I'm going to show you this document in a moment, but as far as you're concerned, this was a document, a business plan that was prepared in 2012, yes?
Well, yes, sir.
All right. And if we go to bundle F, and it's the first volume of bundle F, and we look at document tab 7, it's page 28, or page 17 it starts.
Yeah. Yes, sir.
Yeah, you have that. So this is the business plan you're talking about, yes?
It's a brief business plan for discussion, yes.
Yes, and if you go down to page F25.
23, 24, 25, yes.
Do you see their key assumptions? It says lease rate assumptions, and it says, according to the market research conducted by Jones Lang LaSalle, our assumptions for lease rates on an annual basis, base year 2010, are as follows. So do you think actually that the content of this document was taken out of the JLL reports that you received at the end of 2009?
Yeah, that will be the most recent market study and feasibility study that was given to us at that moment. Yes.
Yes, you didn't go away and do any more research. You took the results of the 2009 study and you basically set them out in a presentation. Yes.
No, it's 2010, not 2009.
No, it's using a base year. Well, are you saying you did another study in 2010?
No, what I'm reading here, it says, according to the market research conducted by JLL Times, our assumption for the lease rate on an annual basis, base year is 2010.
Yes, but the research that you obtained from JLL was obtained in 2009, wasn't it?
No, it was ongoing assignment. It started in December 2009, but I believe they continue throughout the 2010.
Well, they produced a report for you at the end of 2009, didn't they?
That's we said that's final draft on 2009, but apparently it was not the final draft. Could have been they continue because usually the consultant will present something, and you as the owner of that project, you tell him go back and do that. So that was, I would remind, this was December 2009, and most likely it was extended to the 2010.
So you think that there's another report somewhere, do you?
No, the same report, the same assignment was given to them. I'm sure it did not finish on December 2009 because at that time this was not the executable final. We just said as a draft. If you recall, we said this is a draft.
All right, I'm sorry, we've got to go back to the, I don't know what that means. We've got to go back to the presentation that we were looking at. Do you still have that open in bundle J?
Oh, well, I have 3 now open, so you have to tell me which one.
You can find bundle J for me, that would be helpful.
J5. Okay, got it. Yes.
Yeah. So there is a presentation, and this is the one that was sent to the DIFC. I believe it was sent on the 2nd of May 2012. And we can see that, you see at the beginning of the presentation on page J65, yes?
J65. Yeah, that was attached to, yeah, it's May 2nd, 2012. Correct.
from Jane. All right, and you've got on page J81, you've got the CSI concept. Now, that is the full extent of the documents that we have seen in relation to this particular concept produced by CSI. Is that pretty much all that you got, an image from CSI?
No, sir. This is a brief presentation to the top management of JFC. They wanted to understand, but all the detail of this, I'm sure there is much more than that with the detail, with technical, that was being discussed or submitted by the technical party, which is TPM, with the corresponding party inside the DFC. Well, what we took here, this is like a 15, 20 pages or less than that. It's a brief to brief the management about the project with the back history and where we are we now, and what we are heading from here.
So you say, yeah, carry on. Sorry, I didn't mean to interrupt you.
Saying that was not intended to be the submission of the technical concept design. It's just we refer to it here as part of the brief about the whole project. It has a legal, has technical, it has commercial, everything was in that presentation. So it's a brief presentation.
Mr. El-Fadel, I wasn't suggesting the things that you said I was suggesting. So I just ask you just to listen carefully to the question. Are you suggesting that somewhere out there is another document which contains a fuller proposal for a concept for this building that was prepared by CSI? Is that what you're suggesting?
Yes, sir. I'm saying the technical party, which is TPM, has more detail than just this picture, sir.
I see. All right. Can you turn to the next page, please? Actually, turn back a page to J80.
Yes. Design and build.
So it says that CSI expressed an interest in taking the project on a design and build basis. CSI prepared some concepts and so forth. And then it says, and this is, remember, April 2012, at the bottom, no feedback from DIFC yet. So in April 2012, you are complaining, are you, to the DIFC that they haven't come back to you yet on the CSI proposal?
Among other stuff. It's only not that.
All right, but by this point, CSI had been terminated, hadn't they?
No, CSI was not appointed to be terminated, sir. It was discussion with them on a build on design and build basis. So there is no termination because there is no appointment in the first place.
Yeah, but the relationship between you and the discussions that you've been having with them had come to an end, hadn't they?
No, sir. They are still waiting for us to come back to them with the final result.
Can I ask you to go to page 1775, please? Volume 4 of F. Tab 215.
Is it the one in the screen?
It looks like it's half across the screen, unfortunately. Yeah, I'm afraid the presentation software isn't working, but because the presenter is seeing something different from everyone else, so we're going to have to go back to our hard copies, I'm afraid. Yeah.
I got the hard copy, sir.
Yeah, let's do that. That's great. Thank you. Page 1775. This is a slide from a different presentation, the one I mistakenly took you to earlier, which is from, I think, February 2010. Sorry, February 2012. All right. And do you see, this is another, you confirmed earlier that you made this presentation yourself, or you had a hand in it, and it says under the heading funding of the project, do you see this? CSI proposed to fund the project and in return be given some units. The funding structure did not materialize and CSI were terminated. So it's right, isn't it, that by the time you got to April, the relationship with CSI had in fact come to an end, hadn't it?
In return for this project in particular, yes.
Yes, so when you told me earlier that it hadn't, were you mistaken?
What I'm saying, that, well, maybe we use the word terminated here, but I'm not aware of an appointment of CSI to be a consultant to prepare concept in order for them to be terminated. So the word of terminated might be misused, particularly here, just to tell that the relationship or the discussion on this has been terminated. But it's not on, they were not appointed in the first place.
Yes, but there's no prospect of them being involved in the project anymore from February 2012 at least.
At that time, yeah, we were just saying they were waiting and waiting and nothing happened. So they just they're not taking the project further, since we are not coming back to them about DFC is accepting the design they were proposing.
But it doesn't say that, does it? It says the funding structure didn't materialize and CSI were terminated. So the reason that CSI, the relationship with them came to an end, had nothing to do with waiting for feedback from the DIFC, did it?
Yeah, that's the most important thing. They were not rejecting the funding. They were just wanted the signal to go ahead and go further on the project. They didn't get that signal from the first place, from the DIFC.
Well, let's look at that issue quickly. I'm trying to cut through this, my lord, just to get some progress. If we look at that, the involvement of CSI, the CSI, in order to become involved, they wanted an ownership interest in the building, didn't they?
Actually, part of their proposal that instead of borrowing money, they said, again, is the construction, we can take some units later on. And that's form of financing, of funding. We call it construction finance.
Yeah, so they wanted an ownership interest in the building, didn't they?
Units, meaning they will become like a buyer, end buyer of some units against their bill for construction cost.
Yes, and what the proposal was that Tamniat and CSI would form a consortium. That was right, isn't it?
I don't recall this thing, particular consortium, but I recall we had a discussion with them that they will take the whole project on a concept and design and build basis, and after we consume all the equity part, whatever required to complete the project, they will do from their own funding, and in return for that, they will take some of the units.
Well, actually, the proposal, wasn't it, was that the DIFC's interest in the property would be converted, sorry, in the company, the joint venture company, would be converted into ownership interest in floors in the project. That was the proposal, wasn't it?
You mean DFC itself?
Yeah, so CSI and Tamniat were talking about approaching the DIFC to convert the DIFC's interest in a joint venture company into an interest in an ownership interest in part of the project, yes?
I'm not aware of that, sir.
Well, perhaps I can show it to you then. It's page 1542 and it's tab 196, and you'll find it in volume 3.
Sir, I would remind you that I need about 10 minutes break to make my prayers, please. With your approval, my lord.
Where have you got to, Mr. Montague Smith? You're not going to finish tonight, so.
I haven't made as much progress. I was trying to hurry up and maybe try and finish within the next 20 minutes, 15 to 20 minutes. I think that's realistic. It's always unclear, but I think it's realistic. Clearly, it's better to finish than not.
Well, I was just about to look at the timetable and see what was planned for tomorrow.
For tomorrow, we have Mr. Hossen. So we have a single witness. What was planned was obviously to get into the defendant's witnesses. So we're about a day behind. I'd hope to finish Mr. Hossen in a day, and then we can start the evidence of the defendants next week. So that would put us a day behind what we planned, but not in any danger of infringing or losing the timetable as a whole.
Yes, I see that. But if we break now, so that Mr. Al-Fadl can have his prayer time, will you finish both remaining witnesses tomorrow? I mean, Mr. Al-Fadl and then Mr. Hossen.
Again, it's difficult to predict. My estimate is that it'll be a full day with Mr. Hossen.
Yes. Mr. Al-Fadl, how long, when do you need to be at prayer, and how long would you expect to be?
I just need 5 minutes, Your Lord.
Oh, I see. Is the sensible thing to take the break now for 5 minutes then, and then resume? Are you happy to do that, Mr. Al-Fadl?
Yes, absolutely, sir. Thank you so much for that.
Very good. All right, let's take the 5 minute break now. And then when you're ready, just sign back in and we'll get everybody together again.
Thank you.
Mr. Al-Fadl, while we're waiting for the judge, perhaps we can direct you to that document. Ah, it's the judge. So the document, with your permission, my lord, I'll carry on. The document starts on page 1539. And it's behind tab 196.
1539, correct.
Thank you.
Follow-up
Yes.
meeting number 2.
Yes. So this is a meeting between Tamniat and CSI and Dr. Adel. It doesn't look like you were at that meeting, but if you go down to page 1542.
1542.
Yeah. And there's various things being discussed, but one of them is the DIFC project. Do you see that?
Correct.
And it says Tamniat mentioned that the design issue is not the concern now. So that's and then Tamniat stated that they will form a consortium with CSI within a month. So as far as you were aware, was there an intention at that point, at least, to enter into some sort of contractual arrangement with CSI?
To be honest, no, I wasn't aware of this.
I see. And so is it fair to say you're not aware at all of the reasons, of the discussions that were taking place about the terms on which CSI was proposing to get involved in the project?
No, I'm aware that CSI has showed interest to go in the project, and I'm aware that CSI has given some proposals such as, okay, I'll take the project from design level all the way to completion of the project, and they were discussing how CSI will get paid back, whether it's through units or through money or a combination of both. That's my recollection of it. And I recall also we visited CSI in China also. They have shown us iconic projects that they have done before to show their capabilities. I recall all that.
Let's just try and focus in on what I'm asking you about, though. So do you see there at the fourth paragraph down, it says CSI suggested converting the 39% DIFC share into floors so that CHL would be free in dealing with the remaining 61%. This issue will be discussed further to see whether it's agreeable with the DIFC. So you see, that's what I was suggesting to you earlier, that the proposal from CSI was that the DIFC's interest in the project company would be converted into an interest in the project building, which would allow CHL then to deal with the rest of the building, that is, give part of it to CSI in exchange for being involved in the project.
As I said, this is my first time to see this kind of document. It could be an internal discussion between CSI and the TENMIA team. I'm not aware if this has ever communicated to DIFC.
No, all right. And then if we go forward in this same bundle, I hope, to tab 202, page 1645.
It'll be the next bundle, I think.
Oh, thank you. I'm so sorry. Yes. Yes, you're absolutely right. It's at the beginning of volume 4.
Volume 4, okay. Yeah, so yes, I see that.
See the email? And so this is an email to you, well, copied to you from Adele, Dr. Adele, presumably. And it says, Dear Abu Abdulaziz, I hope this finds you well. And then refers to a presentation in relation to the DIFC project. But the bit I wanted to show you was the second paragraph, where he says, I met Dr. Wan earlier this afternoon. And you don't need to turn a page.
No, sir, we are not in the same page. I'm referring to F1641.
1645. 1645.
1645. Yes, okay.
All right.
Okay.
So do you now see this email that was sent to you from Adele? Well, you're copied on it, from Adele to the chairman, and you're copied.
Correct.
And the bit I wanted to, and you see the date, 14th of December 2009, and this is the second paragraph I'd like to show you. It says, I met Dr. Wan earlier this afternoon, and he is telling me that CSI are waiting for JLL to submit their feasibility study, which should include a cash flow, before they can finalize the funding structure. So okay. The thing that was holding up CSI providing a funding structure was they were waiting for the JLL report, yes?
That's back in 2009, sir.
Yes, but they didn't ever produce their funding structure, did they?
My understanding, there was a draft agreement or MOU should be signed. I can't recall exactly what date, but in my recollection, there was a discussion on an MOU to be signed with CSI to provide the funding. I would naturally assume that because before they can give any funding structure, they want to look at the feasibility study. That's any investor you will invite, they will ask the same thing.
Yes. So in 2009, you're waiting for CSI to produce a funding structure, yes?
We're not waiting for that. It's part of the. It could be one of many investors we're talking to. This, just one of them. It's not necessary. This is our only option.
Didn't suggest it was your only option. What I'm suggesting is that in your discussions with CSI, by the 14th of December 2009, you are waiting for them to produce a funding structure, yes?
From this email, yes, I can see that.
You just don't remember it. Is that what you're saying?
I mentioned that to you, sir. I don't recall these details.
I see. But you told us earlier that the reason that they didn't produce a funding structure was because the DIFC had not provided comments on the concept. In fact, the only thing they needed to produce a funding structure was the JLL feasibility study. You can see that from this email, can't you?
Again, sir, you're referring to a different date.
No, I'm not. This is the 14th of December 2009, shortly before the JLL feasibility study, isn't it?
No, the one you are saying that I told you they are waiting for the CFI, the DRC to come back with the approval for the concept. What date was that?
Mr. El-Fadil, we know from your own slides that the reason that the contact with CSI was terminated was because they did not produce a funding structure, ever. That's true, isn't it?
You're referring to the 2012 or 2010 presentation?
No, I'm asking you about the facts. CSI never produced a funding structure, did they?
I didn't say that, sir.
I'm suggesting it to you. Do you agree or do you disagree?
I disagree, sir.
So you suggest, do you, that CSI produced a funding structure?
Like I said, I recall discussing an MOU draft. We wouldn't go to that point if we don't have at least a go-ahead from them that they already have a funding structure.
So if we go back to the presentation at 1760.
1760.
Tab 215.
Oh, 779. Yes.
1775 within that tab.
Okay. I can't find that.
Do you have page 1775? We've looked at this already.
756.
Yeah. 1775.
Yes.
Do you see the second bullet there?
Yes.
The funding structure did not materialize and CSI were terminated. Can you tell me when you've got the page and I'll go forward then?
So you're referring to the presentation on the 2012?
Yes.
Correct?
Yes.
Okay.
CSI proposed to fund the project. So this is setting out the history, yes? CSI proposed to fund the project and in return be given some units. So that happened in 2009, yes, as we've seen.
No, after 2009.
So there's some time after 2009. So I literally just took you to the minutes of a meeting where there was a discussion about CSI funding the project by taking an interest in the units, taking some units from the property. That was in 2009, wasn't it?
Okay, you showed me a minute of 2009 where it says that there is a discussion.
Yes.
A discussion between Tanmiat and CSI about how they're going to fund the project.
Yes.
And you showed me also an email on 2009 where it says that they're still waiting for the study, the GLL study.
Yes.
And now we discussed it at 2012 presentation where
Yes.
we're saying the CSI has proposed the fund. So there is a 3 years.
Yes, but it said,
most likely they got the study they were waiting for.
But the point in the presentation, isn't it? The second bullet point, it says the funding structure did not materialize. Yes. So
materialize with DIFC.
So I see. So your point is that the DIFC should have prepared the funding structure for CSI's involvement in the project. Is that your evidence? No,
sir. I'm saying a proposal of funding structure has been given to us by CSI, which is supposed to be materialized, meaning all the party has to agree to it and sign to it. And since DIFC did not come back to us in the concept from the first place, there is no point to go further on the discussion. That's what we meant on this presentation.
You're just making this up, aren't you, as we go along?
Why, sir? You asked me about my opinion on this presentation. I'm just telling you where I feel. I don't know what to say.
All right. In terms of the funding for the project, bear with me. I do apologise for the breaks, my lord. I'm just seeing if I can cut through a couple of the areas of questioning and speed things up. So if you just give me 2 seconds, I will lean over and get some instruction. Thank you, my lord. Hopefully, the last topic. By the end of 2009, the reality is that the shareholders of Hexagon and CHL had adopted a strategy which was to reduce debt and avoid cash investment. That's right, isn't it?
In 2009, it was clear that putting 100% of the total project cost in cash liquid, that's not foreseeable. So, investor has to come up with other means to fund the project and get it completed. Along with the capital required, we need more. The project costs more than $1 billion, $1 billion dirham. So the amount needed is beyond the capital of the project, and we still need to come up with extra means and resources. Yes. If you ask me about that, yes.
So when you're saying it was clear that putting 100% of the total project capital, I just want to get your words right. You say it's clear that putting 100% of the total project cost in cash liquid, that's not foreseeable. What you mean is that that wasn't something that the shareholders were prepared to do or able to do at that stage.
I'm not saying they were not capable to do it. I'm saying it's not foreseeable because that doesn't make sense to put 100% of the total project cost in liquid cash. But that doesn't mean that they cannot do it.
Yeah, but they're not going to do it if it doesn't make sense, are they?
Yeah, if you look at the discussions was gone before, between 2008 all the way to 2009, there was an agreement between the parties, including DRC, that other ways of getting funding, like other ways of like construction finance, some shareholder loans, others could be considered.
Would you say that for the group, the whole of the Tanmiat International Group, cash flow was tight in 2009, late 2009?
Not the whole group, because we are talking only about the Dubai projects. In other areas like Saudi Arabia, we had cash liquid at that time. But we are not the only shareholder of this project.
Yeah, so if we go to page 1549, please, which you'll find in volume 3, and it's tab 199.
Tanmiat International Business Plan and Strategy.
Yes. So you were you the chief investment officer and the chief executive officer of Tanmiat International at the time?
No, for the Tanmiat group. Tanmiat International is just part of the group.
I see. All right. And did you prepare this business plan?
No, it wasn't me who prepared that.
I see. All right. Thank you. But have you seen this document before?
Yes, I recall we hired Baker and McKinsey at that time who helped us to prepare this document. Was with the help of Baker and McKinsey.
A law firm helped you prepare a business plan?
It's McKinsey. It's not.
Oh, McKinsey.
I'm sorry for that. Yes.
No, not at all. Not at all. So if we go forward to page 1552.
1552. Okay.
Do you see there under the column key findings on the right? Do you see that?
Yes.
And then if you go to the second box down, it says in the second bullet, cash flow management is tight but manageable. So it's right, isn't it, that across the whole of Tanmiat International, cash flow management was tight but manageable? Yes?
Again, to explain to you what is Tanmiat International. Tanmiat International is covering the projects in Dubai, in the UAE only. We have Tanmiat in Sudan, we have Tanmiat in Bosnia, we have Tanmiat in Saudi Arabia, we have in Azerbaijan. So we're talking about UAE.
But this covers, including the DIFC.
Again, DIFC is not our project. We are part of it. Yes.
Yes, but this project, this presentation includes the plan insofar as it relates to the DIFC. Yes.
Yeah, but I just want to confirm that we are part of. We are 37% of the total ultimate shareholder of the investor side.
Yes, but so far as you are concerned and your involvement in this project, do you see on the page that we were looking at, the final bullet at the bottom, it says cash requirement can be eliminated. And in fact, it says all liabilities. Do you see that, the top bullet in the bottom right corner? All liabilities will be eliminated except for legal cases, which we hope to eliminate as well. And then it says, and then the final one says cash requirement can be eliminated. The base assumptions on the left of that, you see, number 3, the aim is to, firstly, number 1, eliminate total project liabilities, and there's 1.5 billion dirhams, to return all projects to be viable and profitable, and then number 3, to reduce and eliminate cash injection by the group and sound cash flow management. So the strategy at the time for the group was to reduce cash injections into subsidiary companies, yes?
Yeah, given the global crisis at that time.
Yes, and if we go down to page 1574.
1574. Yeah, 74.
Yeah.
Yes, sir.
And do you see the action plans? And paragraph 1 is to phase out the development companies and eventual closing down, and various companies are listed, including Concept Holdings Limited. So the intention was to phase out and close down Concept Holdings Limited, yes?
This is like a proposal for the strategy for the shareholders to consider. It was not a decision there. I'm just saying this is a recommendation based on studies with consultants.
I see. And then the recommendation, paragraph 7, is TI should rely presumably for its funding mainly on project financing rather than cash injection by shareholders. And then paragraph 10, liabilities should be at project level and none at holding or corporate level. So is it fair to say that the advice, at least, to Tamniat International was to avoid using Tamniat funds for all of its projects, including this one?
This is a consultant recommending or advice, but the shareholders of Tamniat continue to funding their project from their own resources. As far as I recall, in the Living Legend projects, we continue transferring money. I personally was involved in selling some of our assets and properties in, for instance, in Istanbul, in Turkey, and transferring huge amount. Maybe I can't remember the amount now, to fund those projects that facing troubles of in Dubai due to the buyers stop paying, and,
yes.
and we need to continue the project.
So you had a huge problem with buyers defaulting, didn't you?
Not us, all, even bigger companies, MR, everybody you name it at that time.
Yeah.
Not only us.
No, I'm not criticizing you for having problems with your buyers. There was lots of it going on in Dubai, but something like 70% of your buyers were defaulting, weren't they?
You're talking about what time? Because this situation has been rectified starting from 2011 and going, and projects were completed and delivered.
We're talking about September 2009 here, aren't we?
We just, the whole atmosphere around us is so unclear. And a lot of people at that time, they don't know what's going to happen next. So you have to prepare yourself for the worst.
Yes, but the question was about default rates. In your recollection, around this time, was it about 70% of your purchasers were defaulting?
I can't recall that.
Could be.
77% is a huge number. I wouldn't say that.
70%.
70, right?
Yes.
I don't know. I don't know from where this figure came out.
But it could be that much. Well, I'm asking about your recollection.
No, I don't think we ever came to that level of default.
Because at page 1552, page
1552, okay.
We're looking at a page earlier.
149, 552. Yes, sir.
You see there on the right-hand side, the first bullet, high level of default rates are very likely, can be as high as 70% or more.
Yeah, can be, but I'm not saying it is 70. We say can be. That's the worst, because at that time everybody was panicking. Yes. Everybody was panicking. People were leaving cars in the airport and just fleeing the country. So yes, a gloomy time.
And no doubt that is why cash flow was tight. Yes.
Luckily, it wasn't the reality. Or reality was much better than that.
All right.
It was just people were anticipating the worst.
And you were experiencing problems with Living Legends, the development of that, weren't you?
You at the beginning of 2009?
Yeah. Well, yes.
Yeah, but we salvaged it from Riyadh. We sent money from Riyadh, and we completed the project.
But when it came to completion of the project, there were significant difficulties, weren't there, with the contractor?
Of course. At that time, you have many problems with many people. In most of, I'm not saying all, but most of the developers at that time, they were facing problems due to the financial crisis.
Yes, but in particular, you had a dispute, didn't you, with the contractor for Living Legends, yes?
No, not at 2009, no.
But later you did?
Maybe after I left the company. Until 2012, there was no dispute there.
I see. All right, thank you. Bear with me one moment. Thank you, my lord. Those were my questions. You're on mute, I'm afraid, my lord.
Thank you. Re-examination, Mr. Williams?
There's no re-examination, my lord.
Sorry, did you say no?
No
You said-
re-examination.
I'm sorry, I still didn't get that.
No re-examination, my lord.
Thank you very much, Mr. Williams. Apologise. Thank you very much. Those were all the questions for you, so you're free to go. Thank you.
Thank you, sir. Thank you, man. Thank you, sir. Thank you.
All right. Break now and resume tomorrow.
Thank you, my lord. Yes. Yes.
All right. And you hope to complete Mr. Hosson tomorrow.
Yes. I'll give you updates through the course of the day. As you can tell, it depends a lot on the nature of the witness. But I'm in with the following wind, it should be achievable.
All right. Very good. See you all tomorrow then. Thank you very much.
Thank you, my lord.